Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, on first establishment of the Appellate Division, draws near. The attendance shall be heard. Please be seated.
Good afternoon, folks, on this early spring day. We have approximately 6.5 hours of argument time. I'm sure that you folks don't want to be around here for that long. So we as a panel request that you ask the time you need to convince us of your most salient points. We are a hot bench, I assure you, and you don't have to educate us about your appeal. Having said that, we'll start with the calendar. Oh, actually, one more thing. The red light, when the red light comes on, try to finish up your thought. If my colleagues have questions, of course, they'll continue asking questions over the red light. The red light really is to remind you that argument's over. When the light turns silver, white silver, you know you have 2 minutes left at that time, so think about that. Case number one is People versus Jose G.
Appellate requests 3 minutes and 2 minutes rebuttal.
Responder requests 3 minutes, Your Honor.
3, 2, and 3. Jewish Press versus New York City Police Department.
For the appellant, NYPD requests 6 and 2, Your Honor.
I'm sorry, 6 and 2, you said, sir?
Yes, Your Honor.
Good afternoon, Your Honor. Respondent, 5 minutes.
6, 2, and, I'll give you 6 if you want, because I'm giving him 6. 5 is fine. Okay, you got 5 then. 6, 2, and 5. Number 3, F. Christopher versus Janie F. is submitted. Hoppenstein versus Hoppenstein is the next case.
Good afternoon, Your Honors. Ross Bass for petitioner respondent, 5 minutes.
Okay, I'm going to do 6, 2, and 6. Winter versus Laboratory Corporation. 3, 2, and 3. 517-525 West versus New York City Department of Housing.
Appellant requests 7 minutes for rebuttal.
7, 3, and 5. People versus Richard.
Jameson.
Requests 5 minutes and 1 minute for rebuttal.
I'm sorry, that was Jameson, excuse me. I'm sorry, say that again, what do you want?
5 minutes and 1 minute for rebuttal.
5 and 1, okay, and you got it, 5, 1, and 5. Magnetic Parts versus National Air.
Appellate requests 5 minutes and 2 minutes for rebuttal.
Respondent, 4 minutes.
5, 2, and 4. Barzilia versus Israel Museum.
Appellant requests 7 minutes and 3 for rebuttal, Your Honor. 6 for respondent.
6, 2, and 6. McHugh versus Con Ed. Well, it looks like, you've scared off the opposition. So do you wish to argue or do you wish to submit? Okay, very good. So we'll take that on submission unless we have a late show here. TRB Acquisitions versus Yadid.
Good morning, Your Honor. Good afternoon. James Bernard for appellant, 7 and 3, please.
Your Honor, Edward Ripper for respondent, 7 minutes.
6, 2, and 6. Portfolio Media versus OCA.
Good afternoon, Your Honor. Appellant requests 7 minutes.
Good afternoon, Your Honor. Respondent requests 4.
5, 2, and 4. Tribeca Prep versus Aninis.
Good afternoon, Your Honors. Appellate requests 7 and 1, please. Good afternoon, Your Honor. Sean Dwight from the Dwight Law Firm. Respondent, 4 minutes.
I'm sorry, how much time? 4 minutes. 6, 2, and 4. People versus Harvey Drake. Submitted. Burr versus Crary.
Appellant
4 and 1 minute for reply.
4, 1, and 4. First case up, People versus Jose G. Okay, some clock management issues there, so let's get started. Fortunately, it's not an NBA game. Okay, let's get started.
May it please the court, my name is Laura Boyd, counsel for appellant Jose G. In this case, the record does not establish that the court made the required determination at sentencing that appellant should be denied youthful offender treatment on 2 felony counts. Therefore, this court should vacate the sentence imposed on those counts and remand for a proper determination, as this court had done in Ely. Now, respondent relies on People versus Meinmeier to avoid this result, but Meinmeier has no application to this case because it didn't address the issue in this case. In Meinmeier, the question was not whether the court had made the YO determination at sentencing. Instead, the question was where the court has made the determination, does it have to provide reasons for denying youthful offender treatment? That's not what we're arguing.
What are you arguing?
We're arguing that the court's vague statement that it was going to impose the sentences that were set forth in the plea and the parameters of the plea, it did not give YO on the 2 felonies.
So in essence, what you're arguing is that there were really no reasons given, and it was inadequate, correct?
It's not that there were no reasons. It's inadequate to show that the court even made a decision at sentencing
So is it
after
your,
getting the pre-sentence report as opposed to relying on the plea. I'm sorry.
that's okay. Is it so it's your position basically that you can't tell from the transcript whether or not the judge just accepted the plea or made an independent determination?
Exactly,
So,
yes.
yeah.
And that
Okay.
is the same situation as in Ely. Just to confirm that, actually, the Court of Appeals, in their decision in Meinmeier, specifically noted that when the defendant was sentenced, the court had considered the information that day of sentence.
So really, all you're asking is for the trial judge to say, I've considered this and decided not to do it, rather than just, here's the plea, I'm going to accept it and go forward.
Yes.
Okay.
That's what I'm arguing. Thank you.
Good afternoon, Your Honors. May it please the Court, Elliot Hamilton for the respondent People. Your Honor,
Counsel, how do you get around People v. Rudolph, where the Court of Appeals said that a determination has to be made as to youth offender treatment, irrespective of whether a defendant fails to request it or forgoes it as part of a plea bargain?
well, People v. Rudolph merely states that a determination must be made at sentencing. At sentencing, the sentencing court did determine on each one of these 5 dockets that there would be YO granted on the misdemeanor complaints as by operational law. That
No, how can you tell? I mean, I read that transcript. I know you read that transcript. It's basically, here's what the DA is offering. YO on this count, YO on this count, yes, yes, and those other 3 counts. But there's nothing that indicates in the transcript that the judge made an independent determination as opposed to accepting the plea bargain. I mean, if there is, show me where.
I guess the way that I would point to, Your Honor, is that at the
Just
guilty...
show me what language. When the sentence, just tell me. You have the transcript, so do I. Where is it?
I believe the totality of the record, Your Honor, both from the guilty plea and also the sentencing...
Does case law support that we can look to the totality and make that determination? Don't the cases say that judges do have a duty to make that determination?
They do have the duty to make the determination, but our position is that People v. Minimere merely states that the reasons for the determination...
We agree. Okay, you don't have to put the reasons, but you have to at least say, I've considered this myself, not just I'm going to accept the plea.
I would submit, Your Honor, that by merely stating no YO here, as what was said in the sentencing record, or this is an adult conviction, is more than sufficient, both under Rudolph and under Minimere, to state.
Counsel, couldn't Judge Greenberg have said, based on the facts of this case, defendant's criminal record, the sentencing report, he's not going to get YO on those other two cases?
Well, based on the pre-sentencing report, it would the pre-sentence report that was created for purposes under operational law did not recommend youthful offender.
But didn't Judge Margaret Martin say we will discuss YO status after the pre-sentence report?
She did end up saying that, but I think it would absent any real evidence to the contrary, the presumption of regularity does hold that Judge Greenberg did look at the pre-sentencing report.
How do we know based on this record what he looked at? How do we know? All he had to say was, based on everything here, I am not inclined to provide YO. We don't even have that, unless you can point to it in the record, and we will look for it.
Yeah, it's our position, as I said, Your Honor, based on the record, and based on the record here, I would submit that even if Justice Greenberg did say, or in this case omitted to say, it's our position that Minimere does not require that the court need to state its determination and state its reasons for whether it reviewed the
Counsel,
PSR.
we agree with you that the court is not required to state its reasons, but we need to know why, even if it's limited as to why.
I understand your position on that, and we do ask that the record, as sparse it is enough for purposes under Minimere. We do ask that you affirm.
I mean, you could see, it's like a little burden we're saying. At least say, not, here's the plea, it's this, here's the plea, yes, yes, yes. It's a little thing to say more, and I've considered it, and I'm not going to do it, right?
Understood your point, Your Honor.
Okay.
Do any of my colleagues have any additional questions? Thank you.
Thank you, Your Honors.
Thank you, Your Honors.
Thank you. Jewish Press versus New York City Police Department. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court, Philip Young here on behalf of the appellant. This court should reverse Supreme Court's fee award for two reasons. First, Supreme Court's decision awarding Jewish Press fees for work that it performed between May 2019 and January 2021 is inconsistent with this court's January 2020.
Are you suggesting it's law of the case?
Yes. It is absolutely law of the case, Your Honor. Jewish Press had a full and fair opportunity to litigate it, and there are no changed circumstances that would warrant deviating from that decision. For the second time period, January 2021 to December 2022, fees are not warranted here because the NYPD had a reasonable basis for withholding these traffic violations bureau records.
I'm sorry.
Go ahead.
What was the basis?
That these records were sealed, Your Honor. After the petition was filed and after the end.
So let me stop you for a second. When were the records sealed? Were they sealed before our earlier decision or after?
The records were sealed in October 2019, so before the January
So then
2020.
why wasn't that issue raised in the prior proceeding, and why do you believe you have a basis now, after you get our decision, to assert that unilaterally?
So, Your Honor, the NYPD did raise that argument did raise that issue in Supreme Court. It submitted a reply affirmation, I believe, a couple weeks later, noted that these records had now been sealed.
Was it raised? I mean, I sat on the first appeal, nothing about sealing the records on that first appeal, right? We can agree.
Absolutely, Your Honor.
So then it's done. You can't raise it on the second appeal, right?
Well, no, Your Honor.
You abandoned the argument. You could have raised it. If it was after our decision, I understand, but it was prior to our decision. Why wasn't it raised on appeal?
Well, in the reply affirmation, we pointed out to the court that these records had been sealed, and we said—
Well, it's kind of a reply affirmation. I mean, the horse has left the barn, or whatever the saying is at that point, because it can't be a response to that.
Absolutely, Your Honor, but the nature of the way the facts presented themselves, the NYPD, there was nothing the NYPD could do. It could not assert this FOIL exemption until these records were sealed. And by the time the records were sealed, there had already been an Article 78 petition filed.
But you didn't raise it on appeal, that first appeal. You didn't raise that at all. The only thing you argued on the first appeal was that the argument, that the police investigation exemption applied. You didn't argue that sealing applied, and you could have, because that you're saying now that you raise it. So once you didn't raise it on that first appeal, you can't go back and try and raise it again. You understand that, right?
Well, I think, Your Honor, that the subsequent litigation that occurred, where there was a hearing about contempt and all of the subsequent litigation in Supreme Court that took place, then raised the issue of
That's you. That's you raising the issue. You could have when you got the first decision, you should have just produced the documents. There was nothing unclear about it.
Well, so again, Your Honor, I think the NYPD was stuck sort of between a rock and a hard place here, where we understood the rule that the validity of the agency's denial
You can waive anything in this world. You didn't raise that argument the first time on appeal. You didn't raise the sealing on appeal. So you have abandoned it and waived it. And then you cannot go back again. Do we agree on that? That's a pretty straightforward position. If you don't raise it on the first appeal, and we don't have it, you cannot bring it up after we tell you to, it's not a second bite at the apple.
Well, Your Honor, I think we acknowledged in our reply affirmation that we could not base our argument on the fact that they had been sealed, because the rule is that evaluating the agency's determination must be made based on what the agency did at the administrative level. And at the administrative level in May 2019, these documents hadn't been sealed, so the NYPD could not have raised this exemption.
So here's my frustration, counsel. If you don't give us the documentation, if you don't give us the evidence, if you don't fill out and complete the record that we need to look at, I think that under Khan, we're not allowed, we are barred from addressing an unpreserved issue in the interest of justice. How do we get around that? And I was on the panel. We were both on the panel, Judge Scarpula and I.
I understand, Your Honor. And again, I would go back to, unfortunately, to what I said before, that we were limited in what we could argue in Supreme Court.
You could have easily raised alternative grounds for affirmance of the trial court's position on the first appeal, which is what you are required to do to preserve the issue, right? Yeah, by the time it came up to us, the sealing order had been issued. You knew that it was, you said you raised it below. You could have argued for affirmance under either one of the grounds that you argued on appeal. That's what you're supposed to do. And if you don't, you can't go back to the trial court the second time and try and raise it. I don't think that's controversial.
I don't think that those alternative grounds existed, because again, the exemption...
The decision was in 2019, right? The sealing order?
The sealing order was October 2019.
And 2 years later was our determination. So obviously you could have raised it, and you should have raised it, and maybe you abandoned it.
Well, but again, Your Honor, we could not have made that argument to Supreme Court. Aside from alerting them in the...
You could have made it to us. You could have made that argument to us, because there were changed circumstances, correct?
I don't have a good answer to that question.
Fair enough.
Good afternoon, Your Honors. Samuel Spergel for the Jewish Press, respondent petitioner below. Your Honors, respectfully, this court should affirm the lower court's determination. With regard to the question of whether or not this court's...
Let me ask you this. Isn't Supreme Court bound by our determinations? The rule is that appellate division isn't bound by Supreme Court's law of the case determinations, but why doesn't NYPD have a good argument with respect to the earlier attorney's fee denial?
So with regard to this court's early determination with regard to fees under the fee shifting provision, at least from reviewing this court's order, no determination.
No. This court's order said no fees. That was pretty straightforward,
Yes, Your Honor.
right? So there's no fees.
And this court cited to the fee shifting provision. There was no determination in this court's earlier decision with regard to whether or not petitioner substantially prevailed.
I disagree. When we say that we are not granting fees, right? That has to mean because we found that it was a reasonable assertion, but one that we weren't going with. Otherwise, we don't have the ability not to order fees. So that was pretty clear.
Well, except for the fact that this court, in its decision, I'm not going to dare cite from this court's decision. It's familiar with it.
But we wrote it.
Correct. But the fact that the court said that the NYPD failed to meet its admittedly low burden necessarily means that there was no reasonable basis.
I'm telling you, that's not what that means, okay?
Counsel, clarify something for me. Are you arguing that you should be awarded attorney's fees prior to our January 12th, 2021 ruling?
Well,
Or are we bifurcating your argument?
we would assert a bifurcated argument if the court is deeming that the change in circumstances down below is not sufficient of a change to entitle the plaintiff to an award of attorney's fees beginning from the commencement of the Article 78, then we do take that the change in circumstances, i.e. the necessity of an order to show cause to compel production of documents pursuant to this court's order, and then the lower court's contempt finding for failure of the NYPD to comply.
Do you want to address the sealing arguments raised by your colleague on the other side?
Just briefly, I think the court, in its questioning of my esteemed adversary, kind of got it correct. They waived those arguments. The only two exceptions that were made at the administrative level by the respondent appellant is that invasion of privacy, and then with regard to the Article 78, that there would be a interference with an ongoing judicial proceeding, which again, we do know that they failed to meet their admittedly low bar. They didn't even cite any specific nature of a interference with the ongoing process because the motorist was entitled to get those documents, so therefore there would be no bar from the paper getting those documents. So therefore, the arguments that they were sealed, I think, is a non-issue. Not to mention, during the ongoing litigation, they also asserted a separate kind of sealing with regard to, I think it was Justice Frank. And again, that sealing and that order only came down significantly after this court's order and the order from Justice Perry here. The simple fact is that Justice Perry down below found that petitioner, substantially prevailed, and we substantially prevailed after having to file 2 successive orders to show cause. And with regard to the contempt, the fees that the lower court awarded in connection with the affirmative finding of contempt against the NYPD in this case are separate and apart from the reasonable attorney's fees that respondent petitioner here believes were entitled to as a change in circumstance from and following this court's order because of the efforts that were required to obtain the documents. Nothing can be clearer than the fact that this court ordered the appellant to turn over documents without any exemptions, without any redactions. We had to wait months to first get, and then they decided on their own that they're entitled in contravention of this court's order to turn over documents with redactions. So therefore, given the change in circumstances, that I do believe that petitioner is entitled under the fee shifting provision to an award of fees consistent with Justice Perry's determination at the fee hearing. If there are no further questions, I'll rest.
Thank you, counsel.
Thank you, Your Honors.
2 quick points, Your Honor. First, as to the pre-January 21 fees, this court should reverse, at least as to that basis. Second, for the post-January 2021 fees, if you look at page 64 of the record, this is the reply affirmation that we submitted notifying Supreme Court about the sealing. And we said, in effect, that The sealing should not affect this court's analysis because the court was required to consider the availability of any FOIL exemptions as of May 2019, when the NYPD invoked those exemptions to deny Jewish Press's administrative appeal.
But sir, didn't you ask, in the wake of our decision, didn't you ask for clarification by motion
We did, Your
as to, among other things, the effect of a sealing law? And your motion was denied. So if there was any ambiguity, wasn't it cleared up in our post-decision motion practice?
No, Your Honor. Respectfully, I believe that the denial didn't actually clarify anything because it denied the motion to clarify and didn't say either way whether or not the NYPD could continue to withhold the sealed records as it was required.
Then you're left with our order, which unconditionally and unambiguously said, turn over the documents. It didn't condition it or say on this record or use some other sort of indicator that maybe there was something left to go back and dispute.
I understand that. And again, the NYPD, well, with respect to that issue, the NYPD was again stuck between a rock and a hard place because it was prohibited by statute, by case law, and by a separate preliminary injunction from even accessing sealed records, much less disclosing them to a third party.
So instead, you took the procedure to essentially, or at least arguably, violate an explicit order of ours to turn over the records. And that's the net result of that.
No, Your Honor, I don't believe that our production of the redacted documents violated this court's order. I believe that we were bound by those sealing statutes and Justice Frank's preliminary injunction.
Thank you.
Thank you, Your Honor.
Thank you both. Hoppenstein versus Hoppenstein. You may proceed when you're ready, counsel.
May it please the court, I'm Andrew Labella, the attorney for the respondents' appellants. Under the circumstances presented here, there was reversible error in the granting of successive motions for summary judgment after the first motions were denied on the merits, not denied pursuant to CPLR 3212F, with no new facts presented and no change in the law to justify the granting of...
Would the argument that essentially our prior decision by Justice Rodriguez was new precedent, could that be a basis to say, well, based on this new precedent, we'd be entitled to a second motion to dismiss?
Justice Rodriguez?
No, we're on Hoppenstein.
Oh, I'm sorry, I'm on the wrong case.
We're doing Hoppenstein,
Hoppenstein.
right? Right.
Sorry about that. Go ahead.
Okay, I'm sorry. To justify the granting of the motions...
Okay, so let's talk about the case now that I've been rebooted. So summary judgment was initially denied to you, right?
It was denied on the merits, was specifically denied...
Well, was it really denied on the merits? Wasn't it really denied because there were issues of discovery and there were multiple, there was a lot of motion practice on discovery, correct?
I would judge it was denied on the merits. The denial was in the record as a whole. There are triable issues of material fact as to whether the trustee breached his fiduciary duty of impartiality to the objecting beneficiaries and whether the 2011 distributions constituted an abuse of discretion with an improper...
And then what did the court then do? Didn't the court then grant discovery?
Well, no, there were two motions that were pending at the same time. One was a motion for summary judgment, and the other was a motion to compel. There were two separate motions. They were not interrelated, and one did not refer to the other. They weren't dependent on each other. And it's not a situation where this court can look at it and say that there was error committed below of such a fundamental character and resultant injustice to the appellees that was so egregious that this court should use its general exercise of power to make an exception under the law of the case in the interest of justice, as was done in Rivera versus WNR.
So the most that the court then did was find that on the record before it at that time, there was a triable issue of fact. It did not grant summary judgment, which would be a clear finding of law. The most the court did was find that at that time, based on the record that was adduced, it was a triable issue of fact, right?
But the record had not changed. Nothing changed in the second motion for summary judgment. It was based on the same same facts and circumstances.
But wait a minute, but there was a record.
The granting of the second motion. I'm not talking about the cross.
There was discovery. Discovery took place.
4 years.
Well, clearly the record had changed, right, between the first and the second motions?
Not from the point of view of their motion. Their motion was exactly the same. They used the exact same affidavit in 2009.
Your.
Mine did on the cross
You
motion.
put in things that you didn't put in the first time, right?
I'm talking, that's on the cross motion, Judge.
Okay, so let's just say that there was discovery, and I mean, this is not controversial. You make a motion early for summary judgment in the beginning of a case. The judge says, no, let's do some discovery. Let's see if you can come up with something. And that happens, and then everybody cross moves a couple of years later. The two parties cross move. And what do you put in support of your motion for summary judgment?
Oh, well, first of all, I put in deposition testimony, I put in trial testimony, sworn testimony.
Saying what?
Saying that first of all, there was no documentation to support Schedule A that, quote, a substantial potential for the very significant appreciation.
No, you are arguing, your claim is that the trustee self-dealt. Self-dealt, right?
Say that again, Judge?
Self-help.
Self-help.
Self-dealt.
Yeah.
Self-dealt.
I'm sorry,
Yeah.
right? So I'm asking you, what did you put in to show self-dealing? The trust document itself allowed the trustee to do what it did, which was decant, no doubt about it. And so you've got to put in something to show that that allowed activity amounted to self-dealing. I'm asking you, what did you put in to show that?
Well, I showed that there was an improper motivation to decant because on April 29th, 2011, there was an SCPA demand with regard to the trust. Then on June 25th, 2011, they lost the final appeal with regard to the marina and the fact that the lease had no option.
What has that got to do with the trust, the 2005
Because that was the
trust?
sole asset. That was the sole asset, and the trustee lost $985,000.
Okay, but the fact that the trustee lost money from the trust, right, is not indicative of self-dealing, is it?
Well, self-dealing isn't the only issue, aside from the fact that he did loan the money to himself as trustee of the other trust, but self-dealing
What is the other? What would be the other
didn't say
issue?
Self-dealing, Judge. The judge said, the lower court said, self-serving motivation.
Right, whatever.
Not
That's what I'm
self-dealing
saying.
motivation.
But I mean,
self-serving
clearly,
motivation.
what the trust document permitted the trustee to do, what the trustee did. So you've got to come up with something else other than it wasn't the best business deal.
Well, I didn't say it wasn't that it wasn't the best.
Okay,
business
what
deal.
did you say?
Well, I said that he purposely decanted in order to remove the standing of the appellants so that they could not hold him to account for his $985,000 loss after they specifically.
And what documents did you put in to support your view of that?
I put in that there was not only that it was.
No, what documents did you put in to show that?
The April 29, 2011 SCPA demand, the August 22nd, 2011 SCPA demand, the option to the lease itself, which shows that the option to purchase had expired 2 years earlier, the appeal documents down in St. Martin to show that to show the history of the case and to show that it was a losing case all along and was never, as Schedule J said.
So essentially, it's all sort of bad business decisions, maybe, but is that sufficient?
Well, this isn't about an accounting at this point, in the sense that it's about the motivation of the trustee to remove inquiring beneficiaries who are trying to hold him, who will be trying to hold him to account for that $985,000 loss, which was an egregious loss. That's what it's about, Judge.
Thank you.
May it please the court, Ross Katz for petitioner respondent.
So isn't counsel correct? I mean, maybe the decision was inartfully stated by the surrogate, but at least the decision did seem to say that summary judgment was denied because there were issues of fact.
But, Your Honor, just to follow along that course of thinking, it doesn't mean that's the law of the case. I mean, this happens as Your Honor's.
Well, the law of the case, we're not bound by it.
You're not bound by it. In fact, there's case
But just deal with that. But that's your adversary's, I guess, best argument, is that this is a successive motion for summary judgment. It was denied. We get to go to trial. I mean, that's, in short, what they're saying.
In short, that's his argument. Unfortunately for my adversary, that's not the status of the law. In fact, it was cited in the decision by the surrogate, the freeze-right decision, the freeze-right refrigeration decision, which actually says that the policy against or frowning upon successive motions for summary judgment is not applicable in this situation.
Yeah, but let's get, so counsel says, yeah, I put in evidence, I put in all those documents about the Dutch proceeding. Right?
Your Honor, there's a misstatement, respectfully, in my adversary's argument to this court. In 4 years of discovery, there was absolutely no documents that were demanded by my adversary that was found, with the exception of one, a number 17 on a third demand that was made, that was found proper by the surrogate or by the body sitting before me. Each and every demand was found to be improper.
So let's get beyond that. Just answer my colleague's question here. That what was put in evidence, was that sufficient to raise an issue of fact with respect to self-dealing and the arguments being made that really what the trustee was attempting to do was to remove standing?
My adversary put in insufficient evidence. The summary judgment was appropriate on the second in 2023. Why? Because there were no evidence. There was no competent evidence whatsoever.
Well, what do you say about the documents that he put in about the Dutch proceeding?
That is not competent evidence. It was in an unrelated proceeding. It was not exchanged within this proceeding. Those documents were put in to...
Well, do they establish self-dealing? I don't care where they came from. That's the question.
The question is, they do not establish self-dealing, and more importantly, they don't establish the standing, which was the key issue that the surrogate was looking at here, whether or not the 2011 transaction, the bona fides of that transaction, was a result of improper self-dealing, breach of fiduciary duty, bad faith, whatever have you, by this trustee. There was not one scintilla of evidence.
She allowed 4 years of discovery for them to find it.
4 years of discovery, motion practice, appellate practice, sanctions were issued against my adversary's counsel in the $5,000 because of this. So we've been here before this body. We've been through the court system for now 4 years, and the decision of the surrogate was enough is enough. You don't have any evidence to show that you have standing. If you do not have standing, whatever happened in the schedules of the accounting is immaterial.
Because you're saying that the trustee properly decanted under the trust documents, and there's no question that that was...
Correct.
Okay.
Under the trust instrument, as well as in accordance with EPTL 10-6.6.
But isn't motive oftentimes going to be dependent on inferences that can be drawn from evidence? And here it was not their burden in opposing summary judgment to establish something. It was simply viewing the evidence in the light most favorable to them to establish there was either an ambiguity in the issue or that multiple competing reasonable inferences could be drawn from the evidence.
Well, Your Honor, respectfully, I think in order to even draw an inference, you have to have the discovery of the facts in the first place, and there's absolutely no facts that were presented by my adversary before either the surrogate in over 3.5 years of discovery. I mean, I think in order to draw an inference, you have to at least have the facts before you, and there hasn't.
It's kind of hard, right, with motivation as to what we can't go into the trustee's mind to understand what motivated the trustee to decant the trust.
Your Honor, respectfully, you could take deposition testimony, even though that my client was deceased as of October 2019. I represent his son. There was opportunities over 3.5 years to take deposition testimony, not only of people that knew about information about the trust, but by the successor trustees. They're living, alive and kicking, and there was no depositions taken in over 3.5 years.
Anything else, counsel?
No, Judge. Thank you very much.
Thank you. 2 minutes, counsel.
Your Honor. Okay. A freeze is not applicable, the case of freeze, because it was denied under CPLR 3212F in order to permit discovery on the ground of the existence of a factual issue.
But again, going back to what really happened, I understand. I acknowledge the surrogate did say issues of fact. But if you look at the decision as a whole and the proceedings that have occurred the last 4 years, it's about discovery. And it was the lack of discovery which was the basis for denial of the motions, no?
I don't agree with that. The first motion, you mean?
Yeah, yeah.
No, I don't agree with that, Judge. It was denied on the merits.
And didn't, in that decision, she say, sir, some discovery requests that are appropriate?
There were two motions before.
Right, at the same time, didn't she issue an order that said, fix this up and serve goods discovery requests?
I wouldn't characterize it that way, Judge. She
Okay,
made-
did she issue a decision on the motion to compel discovery?
On the motion to compel
Right,
discovery,
at the
yes.
time, and that was around the time of the first summary
Was-
judgment motion, right?
It was made, there was a decision, it was on the last page of the decision.
Right.
Before that, there was a decision on the motion.
Okay,
for
but
summary
she
judgment,
said,
denied
oh,
on the
right.
merits, full stop.
So would,
Then that.
well, I don't know. I don't know that I would say full stop. What it basically said, I'm not granting summary judgment at this time. There are issues of fact. Do some discovery. And but not the discovery you did, because that's not good. Reserve, right? All right, never mind. Never mind, no problem, no problem.
There was a trial in a similar matter involving the same asset, and there was an abundance of evidence presented on the cross motion with regard to the asset in St. Martin and the motivation to decant. And I did cite cases. You can't look into the mind of a person. You have to look at the facts and circumstances surrounding what was done
But the
here.
problem is that there's really no facts, no records that sort of establish what you're saying that the motivation was to deny your client's standing.
But I disagree with that, Judge, because if you look at the timing of the requests for information with regard to the trust, the appeal was lost in between two of the requests, and then clear that the $985,000 was down the drain. And right after that, on October 15th, he decanted. There's really no question that's why he did it. It didn't happen in a vacuum out in outer space. You have to look at the facts as they were presented. Otherwise, I don't think you'd ever be able to, in a situation, question the motivation for anybody.
Thank you, counsel. Thank you both. Winter versus Laboratory Corporation.
Abraham Winter, plaintiff appearing pro se. Should I summarize or do you ask questions?
Go ahead and make your argument.
I mean, I'm asking for the motion to dismiss to be reversed. I have two statutory arguments, one agency law and one procedural argument about the motion to dismiss searching the record.
So are you aware of case law that says that a creditor that is collecting its own debts is not considered to be a debt collection agency?
I think it hasn't been established that LabCorp is a creditor in this case, but yes, I am aware. There's also newer case law that says they can, including Henson from the Supreme Court and Tepper from the Third Circuit.
Okay. And on the letterhead for LCA Collections, did it say that it was a division of the Laboratory Corporation of America?
Yes. The question there is it clearly labeled, and is the FTC's commentary on that still relevant, given that there's a new agency in charge of that law?
Just the question I have is about your damages. What damages did you sustain here? I think you're claiming reputational damages, correct?
Yeah, I'm claiming that injuring someone's creditworthiness is reputational damage.
Well, what happened? Were you denied a loan, for example? Were you unable to get a job, for example? Anything like that?
In the case of defamation per se, I believe that the standard is a type of information that tends to injure one's professional reputation.
Well, what profession are we talking about even?
I have a list of professions, including my own, including every small business, according to the SBA, that can be damaged by lack of creditworthiness.
So you're saying that is it a $40, $42 debt would damage your ability to be a small business person?
It's not this debt specifically. It's a pattern of debt collection behavior from LabCorp, but I don't know that that matters. I would assume it's the type of information that tends to injure. If it's this one, it could be a different one. It's this pattern of behavior.
Well, other than your assumption, do you have any information to show that anything happened to you? Do you have any documents? Do you have an Equifax report that said that your credit rating went down? Were you denied a loan? Anything like that, other than your personal belief that this hurt your credit?
No, I don't believe it's hurt my credit. I believe...
or it hurt your reputation?
It's the type of information that tends...
I understand what I'm asking you. What do you have any information that would show that that actually happened?
I have evidence they communicated this to a third party, that's all.
That's it, but not that anything negative happened to you.
I'm not alleging actual damages.
I agree. I'm asking you whether or not you have any information or any documents or any testimony from anyone that said that you were personally harmed.
Nope.
Okay.
Thank you, sir.
Good afternoon. May it please the court, my name is Jennifer Horowitz, appearing on behalf of Defendant Respondent Laboratory Corporation of America. This case is relatively simple, and the decision below should be affirmed for two primary reasons. First of all, the court was correct in finding that LabCorp does not fall within the definition of debt collector under the Fair Debt Collection Practices Act. The use of LCA Collections as an in-house collection division of LabCorp did not transform it into a de facto debt collector.
Would the least sophisticated consumer, in seeing that title of collections within the head of the entity, maybe be confused as to the nature of the entity that was seeking to collect the debt?
I think the answer is no, because not only did the LCA Collections follow an in-house division of Laboratory Corporation of America, the invoices in dispute make multiple references that the bill can be paid by logging on to a website for Laboratory Corporation of America, that the debt is for services from Laboratory Corporation of America. There's multiple references within each of the invoices, and in fact, there are three separate decisions in federal district courts that have considered this identical issue with LabCorp as the defendant and have found unequivocally that even the least sophisticated or unsophisticated consumer, which has become the relevant test, would not be duped into believing that a third-party debt collector was collecting here.
What was the similarity or dissimilarity between the contact information for LCA Collections and LabCorp as to the website, the phone number, and the address?
Identical. If you look at the record on pages 69, 70, and 71, there are multiple references. It states, in addition to it being an in-house division of Laboratory Corp, it also specifically states on the invoices, your account has not been placed with a third-party debt collector. The bill is for laboratory work requested by your physician. Make the check or money order payable to Laboratory Corporation of America. Payment to www.labcorp.com/billing. So there's multiple references within the invoices that would make crystal clear to even the least sophisticated consumer that this is not a third-party debt collector. And just switching with respect to the defamation per se cause of action, that also was correctly dismissed and should be affirmed on appeal, the dismissal, because there are no allegations that the alleged defamatory statement, which is the invoices, somehow would negatively impact the business, trade, or profession of the appellant. There's nothing in an alleged invoice that directly would affect the nature of an unspecified business. Thank you.
Thank you, counsel.
Regarding LCA Collections, there's recent case law from this court about clearly labeled as a standard. It's Solomon v. Subway, which talks about the color of text and the relative size of adjacent text. And it doesn't use the least sophisticated consumer standard. It uses the relatively sophisticated shopper or something, but it says that a pattern similar to what LabCorp has in their notice of bright red text next to small, low contrast gray text on a gray background is not clearly labeled.
Anything else? Thank you, sir. Thank you both. 517, 525 West versus NYC Department of Housing. Whenever you're ready, counsel.
May it please the court. My name is Jason Frosch, and I represent the appellant building owner in this case. The owner entered into an agreement with HPD for purposes of allowing HPD to override the zoning requirement for this building that requires obtaining a certificate of non-harassment prior to obtaining a work permit to modify the building. This building was covered under the loft law, and the prior owner had attempted to obtain the certificate of non-harassment. It was denied. The building was acquired by the appellant, and the appellant entered into this contractual agreement. The lower court appears to have completely misapprehended that there is a contract in place, and instead states
So let's
that,
go back before that. You bring in Article 78, correct?
That's right.
What relief did you seek in the Article 78?
Mandamus relief under 7803.
What specific relief did you seek under the Article 78?
The owner had sought an order compelling under mandamus HPD to issue the cure.
You wanted a cure certificate, correct?
That's right.
What is the relief you seek in this action?
So that was correctly dismissed as...
Sir, what are you seeking in this? Are you seeking a cure?
Right. So this
cure
is
certificate or something else?
This is a breach of contract action seeking declaratory judgment, and among many other forms of relief. So declaratory judgment, specific performance, reformation of certain terms that are Scrivener's error. One of the other forms of relief is that there's a declaration.
Isn't the ultimate relief you're seeking here is that you're entitled to a cure certificate, correct?
That is one form of relief, and if the court were to deny that form of relief, there are other forms of relief being requested. Most importantly, a declaration of the parties' rights under this agreement, because the agreement is unclear. The parties have a disagreement as to who is in breach. My client claims that HPD is in breach.
Are you in compliance with what was required of you by way of repairing the low-income housing units in the Section 504 units for disabled people?
So the answer is that this cure agreement only applies to the 4 loft board cure units, and yes, my client is fully in compliance with that.
Were you in compliance on the inspection date?
Yes.
Well, the photographs that are attached to the that are part of the record show apartments in abysmal shape.
Well, Your Honor, these are...
Counsel, they're so bad that instead, you want me to be like really rude? Instead of calling them Exhibit 1, 2, or 3, or however they were enumerated, I would call them Ghetto 1, Ghetto 2, and Ghetto 3. This doesn't show compliance.
Well, Your Honor, first of all, this is a motion to dismiss for failure to state a cause of action and res judicata. It's not a summary judgment motion, first of all. Second of all, those conditions were approved by HPD.
Who is in breach of the cure agreement? Is it you or is it HPD?
It is HPD.
How?
Without question.
How?
Because HPD already approved within this cure agreement a certain scope of work. That scope of work was permitted by the Department of Buildings. It was completed, and the Department of Buildings inspected and issued a TCO.
And did you,
4 years ago.
were you not barred from applying for a temporary certificate of occupancy or a permanent certificate of occupancy until you had completed the necessary repairs?
That's one of the items that's...
And did you not do so?
No.
Did you not go for the C of O, the TC of O, without having been in compliance?
No, the requirement in the agreement is that the owner cannot request a certificate of occupancy until a certificate of occupancy is obtained. So one of the primary issues that I'm raising in the complaint is that there's several circular requirements in the agreement. It says you can't get a CO until you get a C of O. It doesn't make any sense. And I'm arguing it's a Scrivener's error. It's a basis for reformation. At the very least, it's a basis for...
So is this an end run to get mandamus?
No, it's the other way around. I think mandamus was an attempt to say this is a non-discretionary duty arising under public law erroneously.
Counsel, let's talk about that precise issue. So Section 11, I think, of the agreement gives HPD broad discretion to make these determinations, correct?
HPD has the discretion to decide whether or not the...
And didn't they exercise that broad discretion as was agreed to by the parties in Section 11?
No, because the scope of the agreement is limited and defined to the plans. And HPD not only approved the plans, but then the Department of Buildings issued a certification saying that the owner was in full compliance with those plans. And the only items listed in HPD's letter, which by the way was issued after the mandamus petition, so couldn't have been within the scope of that pleading, and for other reasons is totally distinguishable, lists a whole bunch of different items that are not within the scope of the plans, that are not within the scope of the agreement at all, and after repeated requests by my client for clarification as to where these obligations arise within the cure agreement, HPD never provides any basis for it whatsoever.
Sir, going back to res judicata,
yes,
we agree that fundamentally both this breach of contract action and the mandamus proceeding involve the same sort of basic underlying transactions and facts.
No, I think
not relief or theories, but the transaction is the same, is it not? That there was an agreement between HPD and the petitioner, and they had the cure agreement.
There are
at the core of both this plenary action and that special proceeding is the cure agreement, right? And its applicability or enforceability, right?
Yes, but there are also additional transactions and circumstances that arose since that mandamus proceeding that are the basis of this complaint. But yes, it is all about the cure agreement, and the owner erroneously brought an Article 78 mandamus case. The judge correctly dismissed it for lack of subject matter jurisdiction and essentially said your relief is elsewhere.
I think what we're trying to get at is the claims you're making now, couldn't you have raised them in the Article 78 in some sort of hybrid Article 78 breach of contract cases that seem to be the fashion today?
I mean, the judge said this is limited solely to mandamus. And
Sir, initially when you brought the Article 78, couldn't you have raised these claims that you're making precisely now with respect to breach of the cure agreement within that proceeding?
Some of those could have been brought as a hybrid. There is no case law that says it must have been brought as a hybrid. The Article 78 judge...
So how does res judicata affect that what you're saying now? Because res judicata affects...
Were this to be true, that bringing this Article 78 forever bars any litigation regarding this agreement, this is now an unenforceable agreement, even as to circumstances that arise afterwards. So all of the interactions between the parties after the mandamus case would somehow be barred from being enforced because of a mandamus that was dismissed without reaching the merits based on lack of subject matter jurisdiction. This would effectively leave the parties in limbo with an agreement that could not possibly be interpreted or enforced by the courts.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Amy McCampbell on behalf of the respondents. Your Honors, this Court should affirm the dismissal of the complaint because it's barred by res judicata.
So is this an unenforceable agreement?
Not at all, Your Honor. If there were new facts that could give rise to a claim, then the owner could bring a claim. And in fact, the Court contemplated in the first proceeding that if HPD reaches a final administrative determination, then the owner could certainly challenge that in Article 78 proceeding. But the HPD hasn't reached a final determination. The owner hasn't even alleged that HPD has constructively reached a final determination. The parties have continued to be in discussions about how to achieve compliance. There's no new facts between...
Well, actually, so res judicata claims that could have been raised and claims that were raised. But what I'm hearing from your adversary, though, is that there are new claims that came subsequently to the mandamus. Could you address that?
Of course, Your Honor, it's incorrect. So the only new facts in the record are HPD's February 2021 and February 2023 assessments. And all those assessments did was point out the same deficiencies in the same apartments as the June 2020 assessment. There's nothing new. The owner doesn't allege to have completed any meaningful work after 2019. So the work that the owner did was before it brought its first proceeding. It argued in its first proceeding it was entitled to the cure completion certificate. That proceeding failed on the merits. And then 2 years later, the owner, rather than rehabilitate the apartments, it brought a new proceeding challenging
So res
HPD.
judicata wouldn't bar a subsequently accruing breach of contract claim. It's only those breach of contract claims that accrued at the time the Article 78 proceeding was determined.
if there were new material facts, then perhaps there could be a new claim. But there are no new material facts because, again, the owner's entire argument is premised on its claim that it was entitled to the cure completion certificate as of 2019.
So are you saying that since the time of the inspection that produced these photographs, there's been no new repair work done?
My understanding is that was the last inspection by HPD. I don't know, perhaps the owner could address that question, but the owner has never alleged to have completed any significant work since 2019. The owner's position has always been that as of then, it was entitled to the cure completion certificate. And the owner is incorrect to allege that HPD is in breach of the agreement because the owner's position that HPD had to issue the certificate because it obtained a certificate of occupancy from the Department of Buildings simply ignores the language of the agreement. There's 11 conditions in the agreement that have to be met before HPD issues the cure completion certificate. And construction of the low-income housing units in accordance with the building plans is simply part of one of those conditions on page 59 of the record.
Could petitioner have brought, with its Article 78 proceeding, breach of contract claims in the nature that they're alleging now?
Absolutely, Your Honor. And we cited cases in our brief in which the fact that the first proceeding was an Article 78 proceeding, it doesn't mean that res judicata doesn't apply to subsequent proceeding. The owner absolutely could have brought all of these contract-based theories because there's nothing new that caused them to accrue after its first proceeding.
So I'm also hearing or reading Scrivener's error. What's your view of it? Did the cure agreement here comply with the party's original intent, or was there an error as is suggesting by counsel?
Sure, Your Honor. So to state a claim for reformation, first of all, on the reformation point, they could have raised that earlier, so it's barred by res judicata. But to state a claim for reformation, all the cases that we've seen, it has to fit within certain buckets, and they haven't pleaded the facts that could state a claim under any of those buckets. So Scrivener's error, you have to allege that the parties had a different prior understanding that somehow wasn't reduced to writing correctly. And the plaintiff has never alleged that the parties had a different prior understanding. Their claim is that the parties maybe didn't think carefully enough about the agreement, but we haven't seen any cases in which that warrants contract reformation. And their equity-based argument, which is what they fall back on, that also completely fails. First of all, we're not aware of any cases that recognize pure equitable reformation. And second, the equities don't favor the owner because you can see in the photos in the record, these low-income housing units, they're not safe and habitable, as HPD has repeatedly found in inspection after inspection after inspection. So for those reasons, because this complaint is barred by res judicata, and even on top of that, because it's failed to state a claim, we ask this court to affirm the dismissal.
Thank you, counsel.
Thank you.
The argument that these are uninhabitable units is something that HPD is barred from claiming because they're barred by the New York City Charter and black letter law from collaterally attacking the Department of Buildings' determination that this building, as the TCO says.
But before, I understand where you're going with that, but you have an agreement here. They're saying that you haven't complied with the conditions in the agreement. I think counsel says there are 11 conditions you haven't complied with. So I don't understand what this has to do with the Department of Buildings. The claim here arises out of the cure agreement.
So HPD is not permitted to independently add additional perceived code requirements that were not within the scope, that are not defined in the agreement, and that the Department of Building states was already complied with. So their claim that these units are somehow uninhabitable is directly contradicted by DOB's issuance of the TCO, and they are not permitted to dispute that. City agencies
They're not permitted to say that you're not in compliance with the cure agreement?
That's correct, on that issue. They're also not allowed to add new units that are not within the scope of the cure agreement.
A building that has a certificate of occupancy or a temporary certificate of occupancy cannot possibly be in violation of the housing code? Does that make any sense to you?
They're not, HPD is not alleging it's in violation of the housing maintenance code. They're alleging that there are violations of particular building codes and administrative codes that the Department of Buildings reviewed and certified. In addition, the complaint is replete with issues like this where HPD says there is no fire escape. And the owner, subsequently to the determination of the mandamus proceeding, went on an inspection with HPD's inspector and said, here is the fire escape. Can you please remove this from the list of items you're claiming are not done? And HPD said, no, we're not going to do that. And there's a list of issues that are pled in the complaint. On a motion to dismiss, all those allegations are to be credited as true.
Sort of going back to the original theme of the days, couldn't you have pled all those claims in a hybrid Article 78?
And the answer is no, because many of those facts arose after the determination, including subsequent inspections, discussions, and communications between HPD and the owner. And were that to be the determination, this agreement could never be enforced, arguably by either party, since none of those issues could have been nor were raised in the mandamus, which, as I note, was only dismissed as a matter of lack of subject matter jurisdiction. The merits were never reached.
Thank you, counsel.
Thank you.
Thank you both. People versus Jameson. You may proceed, counsel.
May it please the court, my name is Paul Wiener, appearing for appellant Richard Jameson. Since the Orama violation, which is undisputed, affected all 3 counts under the trial indictment, the entire judgment should be
Counsel,
reversed.
what is your response to your adversary's citation of People v. Silva and People v. Walton for his proposition that we should just remand on count 1?
So those cases are very distinguishable, Your Honor. People v. Silva, for example, was a case where there was a jury note that involved a attempted weapons possession, and the court said, okay, that has nothing to do with the drug charge. This is very different. This is a case in which you've got
3 counts of the same?
Exactly, all under related theories, all for the same time period. It's very, very different. The thing is, the jury note in question here asked to hear the judge's reading of count 1, including definitions and details. Significantly, all 3 counts of criminal contempt required a showing of intent, but the court only gave an expanded definition of intent when it charged count 1.
Sir, is the definition of intent the same for the purposes of all 3 counts?
The court's, yes. And
Didn't the court charge only on 1 and said, I've already covered intent on count 1 and didn't define on count 2 and 3 when she was charging the 2?
Exactly, Your Honor, and that's the problem here. So the court gave the expanded definition only under count 1, and then when it got to counts 2 and 3, it said, you've got to go back and go back and consider what I said under count 1 as to the expanded definition. So if the jury wanted to hear an expanded definition to assist its deliberations under any of the counts, it would have had to have asked for a
But when I'm looking at this note, it seems to me that the note is discussing count 1. I agree with you, it says definitions in detail, and there was that discussion on the record of it. But everything else, it's not about intent. It seems to be concerned about a typo, apparently, in the verdict sheet about course off conduct. That seemed to be the concern for the jury. So didn't all that relate to count 1 and not to counts 2 and 3?
Yeah, that's the second part of the note. I agree with that, Your Honor.
No, I'm looking at the first paragraph. Further, can you please confirm if it's up to our determination to decide if something is considered an, quote, course off conduct, end of quote, and, quote, act?
Yes, but before that, the court specifically asked to
definitions in detail.
hear
I agree.
definitions and details, and that's what's important because.
So the rest of the note we shouldn't look to because it seems to be it's addressing count 1.
We don't know exactly what the jury. The point is that we don't know exactly what the jury was seeking here, but there's certainly a very good possibility that the jury was considering, wanted information as to counts 2 and 3, and we can't possibly say that wasn't the case here. And in fact, there is good reason to believe that they may have been focused on intent as to counts 2 and 3. During the period in question, the complainant allegedly received numerous phone calls and texts from Mr. Jameson that none of them contained any threats. So the jury might have concluded that there was no intent to place her in reasonable fear of physical injury, no intent to harass her, etc. Look, again, we don't know exactly.
But don't you think they would have sent a note if there was any confusion about any of the other counts?
Well, I mean,
you're saying because they've sent a note about 1 count.
They sent
so
a note.
So they know how to send a note. They know what to say, But they didn't send any notes about 2 or 3, right?
But yes, but they did specifically say, including definitions, and the only place where the court gave the definitions which related to counts 2 and 3 was with regard to count 1. So we don't know, we cannot say that they did not, that they were not considering.
So it's your position, had the note been discussed with counsel, et cetera, these ambiguities could have been cleared up at that point in terms of what they wanted, definitions in detail?
Absolutely, and Orama says you can't sort of speculate about any of this, and it has to be reversed. Thank you.
Thank you.
Good afternoon.
You may proceed, counsel.
Good afternoon. May it please the court. If ever there were a jury note that seemed to squarely deal with one count in an indictment, this would be that note. It says count 1 in the first and final sentence of the note.
It also says definitions, and we would be in a better place if the note was read and attorneys were able to discuss it, correct?
Without question, Judge.
Thank you.
And clearly, there was an Orama violation with respect to count 1. The people can see that.
So how do we?
We don't know. We don't know that.
Well, we do know there was an Orama violation with respect to count 1.
So how do we deal with the definition and detail portion, which I think is their strongest argument?
Yeah, and Your Honor, there's a statutory construction canon, which I've forgotten the name of, but that talks about how a generalized statement followed by a specific one can give guidance as to the meaning.
That applies to legislation.
It does.
Contracts. These are matters that have been, well thought out and planned. This lay jury writing this note to a judge, they to their credit, they had quite, a fairly detailed note here. But there is this concern with I agree with you that in several aspects of this note, it's clear as day we're talking about count 1. But then there's a clause that reads, including definitions and details. And Orama provides, among other things, a prophylactic function. So we're not put in the position of trying to speculate as to the import or materiality of a jury note.
I think the speculation is, I think there's a pretty weak read to speculate, honestly, that the definitions beyond course of conduct and act were the ones that the jury was seriously confused about. And I would point out that there was a note, in fact, a jury note, I think it was Exhibit 2, that did ask for all the definitions and explanations of all of the counts, but they asked for a written explanation of all of the counts. And then the judge came back and explained that a written explanation could not be given, but if the jury wanted any further explanation, they could ask for one. They did with respect to count 1.
So counsel,
solely with respect to count 1. They didn't with respect to count 1, which is why we agree that count 1 needs to be, the conviction under count 1.
So here's my problem with, and my question concerning your analysis. So those explanations were given with respect to jury notes 1, 2, and 3, right?
Yeah.
So now we have jury note 4, which asks for course of conduct, for definitions as to course of conduct and act, and engaging in a course of conduct, which has a typo. Okay, so if you have responses as to jury notes 1, 2, and 3, and a question that's similar is being asked at jury note 4, does that allow us to infer that there was still remaining confusion and that jury note number 4, which is the last note before jury note number 5, which says we reached a verdict, right? There was no response to jury note 4. How does that affect the big picture? We know how it affects the little picture, but the big picture is the one that's concerning us, obviously.
Yeah, opposing counsel talked about how there was good reason to believe that there was a possible issue with respect to intent. But the examples of possible issues with respect to intent that counsel gave didn't actually create any issues with respect to intent. There were questions perhaps about, especially with count 1, which I think was the closest count evidentiarily, there were questions about whether or not the defendant had in fact opened the window that he allegedly slipped something through in the victim's apartment, whether he had in fact had a good reason for being at her workplace that day, because it was allegedly also his workplace. There were legitimate questions with respect to whether or not there was a sufficiently well-established course of conduct, or whether the acts were sufficiently
Is that
justified.
the test, whether there were legitimate questions within the mind of a lawyer?
Obviously, no, I'm speaking with respect to the jury, and obviously, Judge, of course, we can't speculate about whether or not there were legitimate questions with respect to, all I would suggest, Judge, is that there is no strong reason, any real reason on the basis of the evidence presented in the case, or based on the note itself, to think that the jury had had any questions with respects to count 2 or count 3 of the indictment. And I just want to also say that while it is true that they are under the same heading of criminal contempt in the first degree, the actual conduct that makes up counts 2 and 3 is materially very different.
Or were there
I'm
any
aware,
shared?
counsel. I am aware of that.
Right, so they're not 3 of the exact same charge. They are not 3 different
But they have
theories
an
of the same.
evidentiary relationship, do they not?
Well, so if I could briefly talk about Thomas, the one case counsel cites with respect to this idea that cases are so evidentially linked that they can't be decoupled for ORAMA purposes. In Thomas, what happened was, and they said this in the opinion, the evidence, there was a gun charge and a murder charge, and there was the ORAMA issue happened with respect to the murder charge, but not the gun charge. The evidence in the case showed definitively that the defendant was the murderer, and showed definitively that the gun was used in the murder, but hadn't showed definitively that the defendant possessed the gun. So the murder conviction was what connected the gun and the defendant. You needed the murder conviction for sufficiency purposes to establish the gun possession. So what the Second Department found was that when you threw out the murder conviction on the ORAMA basis, you could not possibly have proved the gun conviction. So that was a form of evidentiary intertwining that actually raised an issue where you could not separate out the charges. Here, they're not evidentially intertwined at all. They're factually related. But there's nothing about count 1 which you need to establish count 2 or count 3.
Also, they asked for the note, correct? And then when it's time to charge, she only defines intent to the first charge, correct?
Yeah.
So now, how do we know? How do we know that the jury said, well, she didn't answer our question on note 4, let's just convict him on all 3?
Because
we
they said
don't
count
know.
1. Because they said count 1. That would be wow.
This is somebody's liberty.
Well, yes.
Thank you, counsel.
Just briefly, again, I just want to say, obviously we're not mind readers, but you can't say that there's no possibility that they were not seeking information regarding count.
So how are all these counts linked, I think, which would help your argument, I believe. So how do you show that linkage, the connection between the various counts?
I mean, I think that, it was all in the same time period. It's all, the same conduct that was alleged in terms of all 3 counts. They're completely factually intertwined. It's totally different than Silva and Walston, where you've got completely different crimes. And again, again, we cannot say, ORAMA says you can't speculate, we can't start speculating, we can't get into the minds of the jury. We cannot possibly say that there was no possibility.
Sir, I know I think I asked you this on round 1, but I'll repeat it because to me it seems important. The linkage would seem to be vis-a-vis this note, the definitions. And so again, I think you may have mentioned intent. In addition to intent, if I remember correctly, you said intent, what is the shared lineage as far as definitions between counts 1, 2, and 3?
The shared lineage is the intent, and the court only gave an expanded intent charge when he charged count 1. But then when he got to counts 2 and 3, said, refer back to what I said in count 1 with regard to defining intent. And since all 3 of these counts relate to intent, there's no possible way that we can say that they weren't seeking information about that. Thank you.
Thank you, counsel. Thank you both. Magnetic Parts Trading versus National Air Cargo Group. You may proceed, counsel.
Good afternoon, Your Honors, and may it please the court. Courtney Brown with Vetter Price on behalf of Magnetic. This appeal involves basic, straightforward rules of contract interpretation and well-established New York law on limitation of liability provisions. We're dealing with 2 sophisticated parties who entered into a lease agreement for an aircraft engine, and the terms at issue are found in a form agreement that was drafted by an airline industry group. Now, the trial court erred in denying Magnetic's motion to dismiss National's counterclaim. While multiple provisions in the lease agreement bar National's counterclaim, The simplest and quickest way to resolve this issue is to just look at Section 5, Romanet 2 of the lease agreement. This is page 278 of the record. New York courts routinely enforce provisions in commercial contracts that bar consequential damages. And that's exactly what this provision.
So how in this case, how do we, or how do you suggest we should read this agreement so it gives meaning to all parts of the agreement? Here, and specifically, it's what I'm referring to are the salient provisions 5 and 12.
Yes, Your Honor. So if you look at Section 5 as a whole, the very first paragraph in Section 5 is an as-is, where-is provision. That's where we're finding the reference to Section 12. So the first paragraph of Section 5 says that National is supposed to continue to lease the engine during the term, as is, where is, except for certain exceptions, one of which is Section 12 of the lease agreement. Looking at Section 12 of the lease agreement, page 283 of the record, it addresses unserviceability of the engine. Now, the trial court erred here because Section 12 provides that Magnetic is only obligated to repair the engine if National continues to pay rent to Magnetic, which it did not. And because the trial court misinterpreted this provision, that's why it's misinterpreting Section 5.
So, counsel, my concerns lie somewhat elsewhere. The engine supposedly was unserviceable, and it's never been returned to Magnetic, right?
It has been returned, Your Honor, but not at the time.
It's outside the record, so we don't need to go down that road. Okay.
Correct.
Sorry.
Thank you, Your Honor.
But your adversary raises the argument that at the point when they tried to return it, there was a bar because the location was so far away that it would have entailed considerable expense.
Well,
how does that play into your argument?
Even if not, we have to take National's allegations as true, of course, for purposes of this motion. Even if there was somehow something preventing National from returning the engine due to Magnetic, National suffered no direct damages because...
No, but that could absolutely be a defense to your claim for rent, right? They could have asserted it for their claim. They also could have asserted a declaratory judgment claim that because you breached first, you're not entitled to your rent, right? They could have those two counterclaim, that counterclaim and that defense would not be barred by the big, giant, all bold, all caps, you cannot do any consequential damages clause, right?
Right, Your Honor.
All right, okay.
And so this, again, this provision is consistent with Section .1 of the lease agreement and Section 10 of the lease agreement. All the provisions are in favor of Magnetic. The risk of loss of the engine is on National, and National is obligated to indemnify Magnetic. Any further questions from the panel?
Thank you, counsel.
Thank you, Your Honors.
Good afternoon. Robert Hampton, Hampton Associates for National Airlines, or National Air Cargo, but it followed National Airlines, actually. To suggest that Judge Reed made a mistake is really, it goes
So let's talk about Section 5. So Section 5 discusses disclaimers and waivers without prejudice, but isn't it really referring to the as-is condition of the engine, correct?
Well, yes, but at the same time, Your Honor, to put this in the right perspective, there was a motion to amend that was objected to, okay, and Judge Reed ruled against them.
We're familiar with...
There was a motion to renew and re-argue, that was rejected.
We're familiar with the
There's
record.
a tremendous litigation here over the same issue. The big picture here is that a company that needed an engine...
Let me start with this. Are you seeking lost profits in your counterclaim?
No.
What is your counterclaim for?
The
Lost business, right?
The claim is for what they lost as a result of having a defective engine because...
Isn't that classic consequential damages?
No, it's not. It's a direct result of them not having an engine.
Is it not what you lost because of not having an engine, classic consequential damages? I mean, that's, I think, pretty straightforward. That's what you're seeking. If you can disagree, but I think it's pretty straightforward.
I'm saying, whichever way you want to frame it, that's what we're asking for.
So your claim is as I read your counterclaim, you didn't let us return the engine to you. And there it is, right?
No, actually, under the contract, our client had no reason not to have the engine repaired, but he couldn't do it himself, but they wanted to do it themselves.
Okay, so that's your defense to their claim for rent, right? You're
reached out
saying,
to
we don't owe you any, well, let me just finish one second.
Sure.
You're saying, we don't owe you any rent because we had no obligation to repair this, right? That's your defense to their claim for rent.
But, Your Honor, to look at this realistically,
I'm just asking you a simple question. Is that your defense to their claim for rent?
well, number one, the claim is that the engine was inoperative. Whether it was returned or not, it was inoperative. It was not working. It was not working.
Right.
For 3 months.
So when you say
Well, it
inoperative,
was never
let's
working,
just-
and our client
Counsel,
wanted to
counsel,
fix it. They
counsel.
wanted to fix it themselves.
When you say inoperative, you say unserviceable. Are we talking about Section 12 issue? What are we talking about?
Section 12, it was.
Okay, so section. Okay, so then going back.
Inoperable. Okay,
Hold
when
on.
The engine is inoperable, okay?
Okay, so let me stop you there for 1 second. So you're saying the engine is unserviceable, okay? Now, as my colleague points out, aren't consequential damages for that have been waived? You may be able to assert as a defense your inability to return the engine, but why should you be entitled to consequential damages? Because we would be essentially reading out a provision of Section 12, which is not consistent with canons of contract construction.
Well, our client is not claiming damages for the engine itself, just the lack of it being used, because.
Okay, so lack of it being used, so loss of business?
Expenses.
Aren't those consequential damages?
Expenses to them, yes, it was expenses to them. And I think a clear reading of this, if you look.
Counsel, don't you agree that those are consequential damages? What you are seeking.
From a breach, yes.
Yes, and isn't there a big, giant, all caps, in bold section that says, under no circumstances will the plaintiff be liable for consequential damages unless you can prove intentional conduct or gross negligence, right?
Okay, and I suggest in this case, both would qualify, because all Magnetic had to do was say to our client, look, there's $150,000, okay, which was put in reserve, which Magnetic still has. All they had to say was, we're going to repair it.
Your claim for, your counterclaim for consequential damages. That's what I'm trying to say to you. Of course you could assert their breach first to relieve you of your obligations. And of course you could have even asserted their breach of the agreement to say that you have no obligations under. You could have asserted a declaratory judgment counterclaim. The one thing that you can't do under the plain language is assert a claim for consequential damages, and you are just now admitting that's what you're doing. So
Well, Your
that's
Honor,
what I can't figure out. How is it that you can do that?
Initially, this contract was with a different company. Magnetic inherited it, and our client inherited it, okay? In the business that our client is in, these things do happen from time to time. And what's anticipated is that whoever leases the engine then uses the money that they've been advanced in order to fix the engine, okay?
So that goes, I think it's a perfectly reasonable argument. That goes to your breach. You're saying that they're in breach, maybe it's an anticipatory breach, they're in breach, and therefore we don't owe any more payments on the engine or whatever it is. But how does that allow you then to say, not only is there a breach, we're entitled to our either incidental damages or consequential damages?
Well, as Your Honor pointed out, unless there's some intent here or some gross negligence, frankly, the other side wouldn't even they wouldn't allow the engine to be fixed, and they wouldn't allow it to be returned, okay?
That's breach of contract, right?
That's a breach of contract, but it also
and
shows
isn't
an
that
intent.
reading of the contract more consistent, which is essentially what your adversary argues, because it gives meaning to both Section 5 and Section 12. Would you agree with that?
Well, I'd agree that when you look at, you have to interpret a contract so it makes sense, okay? And it wouldn't make sense that somebody could lease an engine, have an obligation to repair it or give back the money, keep the money, not take the engine, and then the people who are aggrieved get zero. That's all I can say. That's all, you know? Well, I understand your point, Your Honor.
And I understand yours. Thank you.
Your Honors, just to sum up briefly, National is only seeking consequential damages, not direct damages. Section 12 is only an exception to the as-is, whereas provision, as explained.
So it could have, but did not, for example, in its counterclaim, say that you were required under the contract to use that $150,000 deposit or whatever it was towards your rent. It could have made that claim. You're not denying that because.
No, and part of National's counterclaim includes an allegation that we should have used.
But it's seeking $1 million in damages, so it's not the 150. It's something else, right? So, so what you're saying is there are claims there, but not consequential damages.
National does not have any claims against Magnetic. National was not paying rent to Magnetic while the engine was unserviceable.
I guess
so there was no
you're
money
right.
to return.
I think that maybe there could be claims about who breached the contract first, but those weren't asserted.
Potentially, Your Honor, if those allegations existed and were properly alleged.
Okay.
Thank you.
Thank you. Thank you both. Barzilia versus Israel Museum. Whenever you're ready, counsel.
Thank you, Your Honor. May it please the court, my name is Martin Beanstock, and I represent plaintiffs Eli Barzilai, Dominique Avery, and others on their claims against the Israel Museum based on their conversion of the family heirloom Bird's Head Haggadah. They also assert claims for a plebin and another claim as well. Prior to the Holocaust, the Bird's Head Haggadah was in the possession of Ludwig Marum. He was the last openly Jewish member of the Reichstag. After the Nazis came to power, they arrested him. One of the first things they did, they paraded him before jeering crowds, and they ultimately murdered him. The family was forced to move. Many of the family members left, and while they were in the apartment that they were forced to move from, the Haggadah was stolen from the family residence.
So it sounds like, though the museum would argue otherwise, that the HERE Act would apply. But fundamental question here, at least for me, is did the court abuse its discretion in dismissing the complaint on grounds of form nonconvenience?
On form nonconvenience. Yes, Your Honor, and it did as a matter of law. Under the Supreme Court Kreisner decision, the lower court was required to take into consideration in determining form nonconvenience. It was required to take into consideration the public policy that.
Well, before we even get to public policy, what connection does New York have to the controversy here?
So there are a number of jurisdictional facts that are relevant to the claim. The first is Elizabeth Maroon was living in New York when she made the demand on the museum, which went unanswered.
When was that?
1954 or something.
That's a long time ago, right?
Yeah,
I mean,
She doesn't live in New York now, right?
She doesn't.
And that's, you're saying 60 years ago, she made a demand that her family be acknowledged for the Haggadah, right?
Well, as a starting point, yeah.
Right, okay.
The museum,
And that's what you're saying connects New York today to the lawsuit?
that was first.
All right, let's
and in
assume
fact,
that that's a huge stretch.
Well,
where are all the documents?
So the documents on which we based our complaint were primarily at the Leo Baeck Institute, which is a New York institution. That's where the documents are today.
What documents are you talking about?
The complaint is replete with documents, correspondence, all kinds of information about the Haggadah.
No. About the ownership is the question. Where are all those documents?
So there are very, very few.
And where are they?
There may be some at the Israel Museum. We think that.
Nothing
So
about.
not in New York, right? I mean, that's what we're trying to get at.
Well, Ms. Elizabeth Maroom's daughter, Dominic Avery, is resident in Connecticut.
Okay,
and
so
she's-
Connecticut might have some documents,
Well,
right?
right,
And that's
right.
where the person who's
Right,
bringing
and-
the
and
lawsuit
if-
is,
yes,
right? And this is
but-
a federal statute.
Right, but
Okay, where are all the witnesses?
so there are a few witnesses. As Your Honor points out, they're mostly dead, right? So Dominic Avery might be a witness, and I don't know that there's anyone alive in Israel who's
Also,
really.
but none of the plaintiffs live in New York. None of the defendants are in New York. The painting is in Israel. The transaction at issue is in Israel. Israel has an interest. What is the connection to New York?
So there are a number of connections to New York. The museum brought the Haggadah itself into the New York Public Library for display.
When?
1989.
1989. But because we're here under the HERE Act, and we're here concerning claims that go back.
But the issue for me is, did the court abuse its discretion in granting the motion on form non-convenience grounds? And what I'm hearing from you sounds like Israel's interest is paramount, not New York's interest here, because there are no New York residents. New York has, at most, a tenuous connection to this litigation, unlike other litigation that New York has undertaken relating to the Holocaust.
Right. So if you were to reject the case on form non-convenience, let me start first. The public policy in New York, which the judge did not consider, is that a claim under the HERE Act, and this is under Kreisner, it's an error of law to fail to consider that fact in making your balancing. The judge below did not consider that fact.
Justice Crane spent almost 5 pages of her decision going over form nonconvenience and the Pahlavi factors,
But
and recognized the HERE Act toward the end of her decision.
She recognized the HERE Act in consideration of the due process analysis, but she didn't touch on it in concerning the form nonconvenience balancing, which she was required to do, and which it was error of law for her to fail to do.
But Ken, maybe ask it this way. In light of what we've talked about in the minimal New York contacts at this point, are HERE Act considerations alone enough to warrant the case being heard in New York?
Together with all the other connections that we have to New York. Look,
When you keep saying all the other, we're talking about something that happened 60 years ago, one thing that happened 60 years ago, and one thing that happened. It's not like you've identified a single relevant document or a relevant witness. If the witness is going to be your client, she's in Connecticut. Connecticut seems to me would have at least some connection.
If the court were to decline jurisdiction in this case, it never will be heard anywhere. And the purpose of the HERE Act was to ensure that it would be heard. So in addition to the fact that the demand issued from here, which was when the cause of action arose, right? That's when the cause of action arose, it was a New York cause of action.
So, counsel, I want to say that reviewing the record here was very painful. Understanding the history of this Haggadah, Haggadah, I understand that's the right way to say it.
Yes.
Is following a very tragic trajectory in a genocidal point of history. All right, so we're very clear on that. And frankly, the refusal of the Israel Museum to acknowledge the family in the way that it wishes is a real question mark for me too. We do have foreign nonconvenience as a block here, so that everything that you can provide us with will be extremely useful in making an analysis. Now, I know that you made an analysis with respect to the publishing place, Corin,
Yes.
which was doing the pop-up books
Yes.
of this 14th century document.
Yes.
But is that a nexus sufficient? You know, also the address at 100 Church Street, is that a sufficient nexus?
Absolutely.
And lastly, if I can just throw everything into the basket. Another major issue is whether there's an alternative forum that is sufficient to consider the questions that you raise. And I'm asking you directly, do you say that the Israeli judiciary is not competent or is biased or prejudiced in any such way, or that there are issues that would impede the Israelis' judiciary from hearing this?
Right. So let me take the last one first.
Please.
The statute of limitations would not permit this to go forward in Israel. If it doesn't go forward
As
here.
a defamation?
The challenge with the defamation claim is that without the conversion and replevin claim that underlies it, we don't own the Haggadah. So they would presumably say, you can't bring the conversion and replevin claim, you don't own the Haggadah, therefore you can't bring that other claim either. But Your Honor, you did touch, so there's nowhere else to go. This is it. And you did touch on the sale of...
I understand, and I think we're all sensitive to these claims, but is that the paramount factor we look at, or do we look at factors, other significant factors, like the plaintiffs don't reside in New York? I mean, isn't that a more dominant factor, a more important factor to consider?
Two paramount factors: Holocaust-era art claim, nowhere else to go, and connection to New York, including, Your Honor mentioned the sale of the pop-up edition. The claims are for conversion and replevin. And this book that they sell, what do museums do? Like, what does it mean to own the Haggadah? What's the value? The value is in displaying it publicly, which they did here. And the value is in publishing a book that says, this book is in our possession, is in our collection. That's what it means for a museum to own a Haggadah like this. They came into New York and they said, we own this Haggadah here in New York. Elizabeth was living here at the time that it was displayed at the public library. She couldn't go into the library and take back that Haggadah.
She could have sued, as other Holocaust survivors have done when art has been brought into New York.
She couldn't have anymore because the statute of limitations had run. So she had that.
She could have attempted to sue.
In 1953, no one in 1953 knew to bring a claim like this. That's what the HERE Act was passed for. So there are two big public policy reasons that the claim should be here. And they sold that pop-up edition into New York through their distributors. Their affidavit acknowledges that they sold through their distributors into the United States. And then we said...
Maybe that goes to jurisdiction, but how does that connect to forum nonconvenience?
It brings them here. Your Honor, when you think about trying this case, forum nonconvenience is right, the convenience of the court in trying the case, it's 3 expert witnesses. I mean, the documents, there'll be a handful of documents. There'll be a few expert witnesses.
No, there'll be people from the Jewish Museum, right? The museum.
The Israel Museum.
The Israel Museum.
But the people,
right?
the people who...
And the plaintiff who lives in Connecticut. So nobody who's testifying in this case lives in New York. None of the documents that are going to be relevant are here in New York. Nothing that is going to be used in this trial has any connection to New York.
The documents on which we based our complaint came from a New York institution.
What documents are you speaking of?
I think it's the documents that
Talking about the New York Public Library and the fact that there was an exhibit there?
No, the history of the Haggadah, and I think the prior ownership claims, but I can't tell for certain. I know
that's why I'm asking you. You're saying it as if you know there are documents here. What documents are there?
I know that in drafting our complaint, which is extremely detailed, those were the documents we relied on, and they're in the Leo Baeck Institute.
What documents did you rely on?
I can't say that now, Your Honor.
Thank you.
Thank you, counsel.
Thank you.
You may proceed, counsel.
And I have to ask you, the first question is this case dead?
Is this case dead?
Yeah, if we dismiss it on forum nonconvenience grounds, is there no other place where it can be brought?
Unclear. As to their third claim for slander of title, that's clearly not time barred, and they could bring that in Israel if they want to bring it in Israel.
Well, could they bring a claim in Connecticut? where a plaintiff resides in federal court in Connecticut under the HERE Act?
They, well, you know, I heard your first comment about the HERE Act. Obviously, we don't agree
I
on that.
understand
So
that.
putting that aside, we think there's still a personal jurisdiction issue as to the Israel Museum in Connecticut. The Israel Museum,
So in other words, they could bring a claim in Connecticut, but there may be, there are hurdles that they have to overcome.
yes, they are hurdles they have. Here, there's even more hurdles, right? I mean, there's no party here. You pointed out that one of the plaintiffs is in Connecticut. The first named plaintiff is in Israel. The other two plaintiffs are in Germany, and the defendant's in Israel. The transaction that's at issue here happened in Germany and then happened in Israel.
It's an interesting way of characterizing this
As a transaction, yes.
The
theft.
Events.
The theft.
The alleged
Well,
theft.
let's call it for what it is. You know, we're not, we're not ignorant, none of us here are ignorant as to how it was this painting, that this family came to be dispossessed from this painting.
It's not a painting, but it's
I'm
a
sorry,
book.
this dog.
Artifact, religious artifact.
It's a book. Yeah, so the book, the allegations are the book was in their apartment. Most of the people left the apartment.
Well, and why did they leave?
They left because of persecution.
Right, so,
Yeah,
and you're suggesting under those circumstances, they have to leave and the HERE Act wouldn't apply?
And the last person who stayed in the apartment
Was Elizabeth.
was Elizabeth. And after she left the apartment, when it
Well, she
was
left or she
stolen,
fled? Did
she
she-
went.
I'm sorry, with
well,
that character.
she went to Berlin for 2 years to study massage and physical therapy.
What year was that?
From 1934 to 1936.
Uh-huh.
She didn't leave Berlin and go to France until 1936. The Haggadah was allegedly stolen in 1933 when she was in the apartment alone. And every allegation is that it was, as Justice Crane found, neighbor stolen art, not Nazi stolen art. And the person who ended up
Well, I don't think the original owner of the work would have left his apartment save for the rise of the Nazi regime, right?
That's definitely true. The Haggadah was in his law office, and Elizabeth retrieved it from the law office, brought it back to the apartment, lived in the apartment by herself, and then, as I said, moved to Berlin for
The family
2 more
was
years.
dispersed when he was arrested, and then he was executed, right?
He was executed in 1933, and it's a terrible thing that happened.
So here's my question. The museum made a request, a demand that the provenance or not the provenance, yeah, that the provenance of the Haggadah be explained by indicating or establishing where it was during the mid-30s to, I believe, 1946. Am I right?
From they asked when individuals came to them long after Elizabeth went to them multiple times in the 1950s and the 1980s, they said, do you have documentation of what happened between 1933 and 1946? That's true.
And in your view, that was a request that this was a real request, or that was a perfunctory request?
Well, I don't think it was perfunctory. I think that there was a lot of documentation. There were people who were around who knew what this Haggadah was and knew where it was in the 1950s. And those people went to Elizabeth Marum in New York and told her about it. And she made a demand to the museum, and the allegation is that that demand was ignored. Okay?
Not only did they tell her, they asked her to relinquish it, that it should stay with the Jewish people, and she said
They didn't say that. So in 1951, Mr. Jesselson
sees it,
he saw it,
goes
and
to
then-
her.
Well, first goes to the museum, and then he does his own investigation. They say he's our agent. He wasn't our agent. He was, if anything,
He did
acting
his
against us.
investigation. He goes to the neighbor. The neighbor couldn't verify that he was sold the painting or that he had rights to the painting. Correct?
These are all the hearsay facts from 1950s, right? I mean, which is part of the problem. If she had brought this case between 1951 and 1954.
So let me hear the facts as you think they are.
What's that?
Let me let you finish your thought. You were going to tell us.
And then subsequently, Ms. Marum came to Israel in 1984, and at the invitation of the museum, she came. They took it out of the case where it is, which is sealed up, and they let her look at it. They reviewed it with her. talked about it with
Was
her.
there a fly piece at that time, or had it, with the name of the Marum family, or had it already been removed by the museum?
It wasn't removed by the museum ever. That's the allegation. That's not true. So
So that would be a matter that could be determined at discovery, for example?
I mean, I know the answer, but yes. So but in any event, it's irrelevant because Exhibit 4 to the complaint is an exact replica of what was in there, which they have because the director of the museum wrote it all down and it was typed up. So we already we have that. We know what it was. We know exactly what it was.
So, sir, I'm sorry. Go ahead, finish.
Your adversary says that this matter cannot be heard within the Israeli judicial system because there's a statute of limitations. There's a statute of limitations with respect to replevin and conversion, and there's a big question mark as to defamation. And you agreed with that. So
I don't agree with that.
So
they got the red light.
It's okay.
Though, so
I'm asking you a
Remember,
question.
the light is for you, not for my colleague.
All right, I will continue.
Okay, so in your view, this matter can be heard in an Israeli court?
It's certainly possible. Number one, I said that the defamation of title claim, the way that they've alleged it, is supposedly a continuing tort, right? So that's there. Then separately, the only thing that they say is that a statute of limitations law that was passed in 1958 bars events that happened in 1946, 1951, and 1954. So I think that's a matter that the Israeli courts need to resolve. They know how to go to the Israeli courts. They have Israeli lawyers. They came to the museum with that. They went to the Israeli family court. They got all sorts of orders for these folks in Germany and Connecticut and Israel to become, declared the heirs. This is a matter for the Israeli courts to decide.
So going back to forum non-convened, I mean,
Yes.
that's which is what we're here
Sure.
for. So is there anything more you want to add to that?
Yes. I would say that there's, to your point, the burden on the court is high. The documents are, everything is German or
I want to ask
Hebrew.
you one fast question because I know you have a red light. What do you say to counsel's assertion that the sale of the booklet here in the 80s is a significant connection to New York?
It wasn't sold. It was displayed.
Oh, just right.
It was displayed at the New York Public Library.
The pop-up.
Oh, the pop-up Haggadah.
Still available on Amazon today, right?
Pop-up Haggadah is a children's book that is merely adopted from the Haggadah. They could have made one if they wanted to. Anyone could have made one before. Now it's copyrighted before. It's the words of the Hebrew words of what's in the Haggadah have been the same for thousands of years. There's no English in the.
But doesn't it have the same
It is a reproduction of the Haggadah.
Not a reproduction. No.
The pictures are.
The pictures are an adaptation. I've seen both, right? I mean, I was there last month. The pictures are. I mean, yes, they have birds' heads on them, but they're
And the hats, the special hats.
Yes, it's an adaptation of something that's public and somebody could have done. Now it's copyrighted, right? Because Corin has a copyright, Israel Museum has a copyright on this, but this is not something that they would have been prevented
Why
from
is
doing
that
before.
not a sufficient connection
Yeah.
to the artifact for us to say it was an improvident exercise of discretion in granting the motion?
Number one, we have evidence that's actually come in from the director of the museum. The Israel Museum never sold it here. The Israel Museum sold it at the Israel Museum store in Israel, which is a store at the museum like any other museum that you go to. They had, Corin is the one who sells it. Corin is an Israeli publisher. They didn't sue Corin. Justice Crane pointed that out repeatedly. If they really had a big problem with this Haggadah, they should be suing, with the pop-up Haggadah, this children's edition, they should be suing Corin. They haven't. So the Israel Museum and the 100 Church Street thing, Your Honor, you point out, so that is not the museum. There's evidence in the record. We put that in from affidavit, which we count on a personal jurisdiction issue. It is a store in Israel that sells some goods for some Israeli companies. It's called JWG Limited. It's not us. It has never been us. So, and it's a post office box anyway. So all of those reasons are why this is not the Israel Museum trying to sell this Haggadah into the United States. The numbers are all in the record, and they're minuscule.
Thank you, counsel.
Just briefly on reply, Your Honor. First, the Israel Museum did sell copies of the pop-up edition through its distributors into the United States. That's in the record at page.
No, we're talking about New York. I mean, sure, we're
Right.
talking about New York.
Right, but the court could take
So
judicial
that
notice.
would be an equal thing for every single state in the United States, right?
Except,
And that would automatically mean no abuse of discretion.
except, Your Honor, that the population, the Jewish population and the Haggadah using population of the United States is strongly concentrated in the state of New York, and certainly it should be sufficient to allow us to get to take discovery on
But
that.
that goes to jurisdiction. I think really the question in our minds, or at least my mind, is forum nonconvenience.
And I wanted to get back to you on that, Your Honor.
Please.
We do link to the Leo Beck Institute in our reply brief, which is the source of the documents. Elizabeth donated her document collection to the Leo Beck Institute, which is located in New York. It has, for example, the correspondence between Elizabeth and Yesselson, which is relevant to the issues in the case. So there are documents here. I would gainsay that there are more documents located in the state of New York relevant to the dispute.
So that may be one factor that we could say that maybe tips in your favor, but there are other factors that don't. For example, the lack of residence, the fact that the central events or the central horrific events that occurred here were outside New York.
Yes, Your Honor, and it is a balance. I acknowledge it is a balance, but I think weighing most heavily in that balance should be that Congress has said and New York policy is. New York passed a law that
Well, you can bring, there was nothing stopping you, and obviously you made a strategic decision not to bring a case in federal court in Connecticut.
Yes, Your Honor, but we do think we have jurisdiction here. We think that it is a convenient, and we think the policy is not just a federal policy, it's also a New York State policy, and it was recognized by the New York Court of Appeals, specifically on that forum nonconvenience issue. When it comes to forum nonconvenience, the court needs to take, and that was error below, right? The court needs to take that into consideration, and looted art as well as an issue for consideration by the court. We've got enough here that you should follow your inclinations to find a way to get to justice to allow us to proceed with this case.
Thank you, counsel. Well said. Thank you both. TRB Acquisitions. Good afternoon, folks. Whenever you're ready, counsel.
Thank you, Your Honor. Good afternoon. James Bernard for the plaintiffs. There are 3 points from our briefs which I think succinctly capture why the decision below should be reversed. The first point is that CPLR 3211E really could not be any clearer. What it says is, and no more than one such motion, referring to a 3211 motion, shall be permitted.
Are the circumstances here unprecedented, maybe based on the prior decision that we made, that should be an exception to the rule?
No, Your Honor, I do not believe they should be, and I have 2 reasons why. The first reason, I think, is perhaps best exemplified by this court's decision where it has granted or has permitted a second motion to dismiss, and that's in the Ultramar Energy decision, which I should mention, by the way, even on these facts that I'm about ready to cover, was a 3-2 decision with the dissent disputing the ability to make a second motion to dismiss. What basically happened was, on appeal, the court reinstated a complaint, in particular a cause of action for unjust enrichment against the defendant Chase Bank. What the court pointed out was that there was no evidence in the record that Chase actually had received an assignment. And so, as this court pointed out after the second motion to dismiss was filed, on remand, so to speak, Chase supplied that documentary evidence. And as the court noted, it sort of took the cue from the court that there was nothing to evidence that assignment and provided it. And on that basis, the summary judgment decision or the motion to dismiss.
And how is this case different from that case?
Well, this case is different from that case for a few reasons. Number one, there was a nexus between what happened in the first decision and Chase's second motion to dismiss providing that evidence. There's no nexus here between an anti-SLAPP argument and the decisions which held in the first case that the absolute litigation privilege should give way where there's allegations of extortion. So the difference, Your Honor, is the absence of that nexus. Another, I think, key difference between those two cases is that the second motion to dismiss was, if you will, because it was based on a document, almost perfunctory. The court pointed out in the first decision, Chase, you haven't established that you actually took an assignment of what's at issue here. And Chase, in the second matter, said, well, yeah, we do, Judge. We have that evidence, and here it is. So it's not a completely separate legal grounds or analysis like the one here that's based on anti-SLAPP.
Well, that's more akin to renewal in a sense, well, even that's questionable, but in any event, so go on.
That's correct, Your Honor. But I would add...
Sir, along those lines then, renewal generally is a discretionary determination. And here, Justice Schechter seemed to spend some considerable time, putting aside the time she put in preparing, on the record during argument, considering the single motion rule and whether there ought to be a dispensation there from here. So do you agree that it's a discretionary determination? And if so, why should we disturb Justice Schechter's exercise of that discretion?
I do not believe it's a discretionary decision, Your Honor, because I think this goes back to the language in 3211, which specifically says that a second motion to dismiss shall not be permitted. I do not believe that leaves any ground for discretion. And I would point out...
In other words, you're saying that there are no judicial exceptions to that.
That's correct, Judge. I think that, look, this court recognized an exception before, but I think by virtue of the fact that, in addition to what I described regarding that decision, that the decision was 3-2, I think judges struggle with how broad those kinds of judicially crafted exceptions should be. And I think that in this case, Your Honor, it should not extend to an anti-SLAPP argument, which could have been raised the first time around. Again, there's nothing about the court's decision which addressed this extortion exception to the absolute litigation privilege that all of a sudden calls to mind, hey, I've got an anti-SLAPP argument I could make. That's something that could have been raised the first time. And I would just point out on that, I think one of the things that Judge Schechter, and you're right, Your Honor, she did carefully review and was carefully prepared for that argument. But I think one of the things that she really focused on was that, at least at the time of the initial motion to dismiss, there was perhaps the perception by defendant that the absolute litigation privilege argument was airtight. And that's the phrase that I believe is used throughout the record below. But we know that the defendant raised a second argument on that initial motion to dismiss, which was that damages were speculative. Now think about that for a second in light of that. If it was so airtight, why would the defendant raise an argument that damages were speculative? If they were concerned enough about the argument to raise that argument, they certainly could have raised the anti-SLAPP argument.
Well, it sounds like then, but by your lights, the question then would become, because you acknowledge there are situations where there are multiple 3211 motions within the life of one action, but it really boils down to whether, at the time the original 3211 motion is made, whether the ground is available as opposed to potentially necessary.
I think that's one way of looking at it, available versus necessary. I'm not sure, Your Honor.
Certainly availability, though, like if the ground existed at the time, even if we didn't foresee maybe we need to raise it, it did exist, and therefore it should have been raised.
That's correct, Your Honor. And I think what that reflects, therefore, is that the decision not to raise it was a strategic one. It was a voluntary strategic one because other grounds were raised, and I don't think there should be an exception to the 3211 rule for strategic decisions not to include something.
Thank you, Counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. Edward Whipper, Benish, Friedlander, Copeland, and Aronoff for Respondent Yadid. And obviously, I'm here seeking affirmance of Justice Schechter's order on all grounds. And as you recall, Justice Schechter dismissed the complaint under 3211G, which was a slap decision. And before doing so, she invited, both her and Mr. Rand, her principal law clerk, invited an amendment of the complaint. The complaint is long on allegations of extortion.
So just to that point, so
Yes.
going back to
Yes.
availability, I guess, it was clear back then.
No, Your Honor.
It was clear based on the allegations
No.
of the, let me
Sorry.
finish, of what the claims were, that the defendant knew testimony that there was going to be a threat, there was extortion attempts. That was all in the complaint. So wasn't that, at that point, that something that should have been raised?
No, Your Honor. Everyone is buying a premise that and accepting an omission from the plaintiff's presentation. And the omission that everyone is accepting from the plaintiff's presentation is that this has always been an extortion case. That's not what the court did in its decision. It's an extortion with perjury case. But before this court made the decision to make it an extortion with perjury
But
case.
it's not, I'm not sure I even accept, it's not an extortion case. It's a breach of contract case.
Yes, Your
Underlying case is breach of contract.
So let me back out for a second and take this back to the original premise here. Originally, it was a breach of contract case, and under paragraph 85 of the complaint, it was a breach of confidentiality for things that were true and a breach of non-disparagement for things that were not true. It was all of the statements that the defendant was alleged to have made against his brother's company in an arbitration. What this court did when it said that when it created an exception to the litigation privilege and said, if there is extortion combined with threats of perjury, then the claim can go forward, is it created essentially a different claim, a claim that was based on falsity. It didn't matter in the beginning of the case whether or not the claims were true.
But how can the court create a claim? A court is only responding to arguments. What the court, I think, was simply holding was that there is an exception to the absolute privilege, and this, we say, is an exception to it.
No, Your Honor, the court created an exception to the absolute
You know
litigation
something, I
privilege.
was on the panel. And
You were.
So was Judge,
You were.
yeah, so was Judge Scarpula.
No, she wasn't.
It was just me?
It was just you, yes, Your Honor.
Sorry, just me. And I'm intrigued by everything that you're saying because you didn't bring this up before.
Your Honor.
How come you get a second bite at the apple? Since when do people get the opportunity to make two motions to dismiss under these circumstances?
Your Honor, respectfully, there was no occasion to bring it up before because the threat of false statements of perjury were not part of his claims. If you look at paragraph...
There was no allegation in the complaint that, in fact, that those statements were made?
In fact, it's a qualified allegation. It says, although they are false, if you look at page 85 of the complaint, although portions are false, paragraph 92 of it says there are other statements that are true, and paragraph 92 of the complaint, otherwise they can't be confidential.
So you made a strategic decision, having read the complaint, that you were not going to pursue that avenue and talk about statements in the public interest, public participation, being covered by the provisions of the anti-SLAPP statute. You made a strategic decision. Don't you have to live with that now?
No, Your Honor, there was no strategic decision. The element of falsity as a defense was not present, and therefore actual malice under the SLAPP statute was not available. It was the court's decision to create an exception where falsity had to be proven to circumvent the litigation privilege or to fit into an exception.
That's what happened here, right, sir? The cause of action essentially remains the same. It was cognizable before. What we did was we found an exception to an absolute privilege, a defense, if you will, that now is in your hands. And now it's sort of modified your defense to the action based on you thought you had an absolute defense. It turns out you don't, and the privilege has been an exception to that privilege has now been recognized by this court.
Well, Your Honor, that's partially true. I think that the important thing to add is that essentially an element that the plaintiff has to overcome now is he has to prove that the claims were false. If the claims were true previously, and therefore they violated the confidentiality provisions of the agreement, my client would still be liable. So therefore falsity as a defense with respect to actual malice on a SLAPP claim wasn't available to us on a motion to dismiss. The actual malice defense, which is the gravamen of the SLAPP claim, yes, Justice Scarpullo,
No, I mean, I don't understand how you could even, you're flipping it. You have the defense, you have the anti-SLAPP argument at the beginning.
No, Your Honor, we did not, and I'll tell you why. I'll tell you why. At the beginning of the case, the plaintiff alleged that regardless of whether what we said was true or not, they were entitled to recover under a theory of breach of confidentiality.
Right. And then what did you move to dismiss? On what basis did you move to dismiss?
Litigation privilege, Your Honor.
And the court said yes, absolute privilege. And then we said, wait a second, there is an exception to the litigation privilege. That's all we said.
But Your Honor, the exception by its very definition required the plaintiff for the first time to prove that the statements were not true in order to prevail in the litigation. Once there is a need to prove that a communication subject to a SLAPP statute is not true, it then triggers the requirements of Section 76A.
No, that's not the way it works. That is what I am objecting to. You're saying for the first time, you knew that there could be an anti-SLAPP claim.
Absolutely, Your Honor, because if the claim was...
How is it that this is the first time? Let's just talk about anti-SLAPP. Why could you not have asserted that right from the beginning?
Because if the plaintiff concedes, as he did in the complaint, that regardless of whether or not the statements are true, they breach the contract, then I cannot assert actual malice as a defense in a motion to dismiss.
You can absolutely assert it.
No,
you don't have to. You can assert it.
The standard for actual malice is that the statements have to either be knowingly false or be made with reckless disregard
But we didn't make
of their
any
truth.
ruling that the statements were knowingly false or could be knowingly false. We didn't go anywhere with that.
This is so novel, I cannot begin to tell you.
Well, Your Honor, it was a response to an extremely novel exception to the litigation privilege.
Counsel,
But
all you had to do is make out the basic elements of an anti-SLAPP case, a motion. That's all you had to do. And then the burden would have shifted, right, to the plaintiff to show that this was public participation, public interest, whatever the statements were.
But Your Honor,
Malice didn't have to be established to trigger the anti-SLAPP statute.
No, but but in order to satisfy the defense under 3211G, in order to obtain dismissal of the complaint on anti-SLAPP grounds, I would have had to demonstrate a failure to plead falsity with actual malice. Unfortunately, at the time, until the court said that the only way for plaintiff to make it through its breach of contract claim was to...
Wait, are you saying that there was no plead of falsity in the complaint?
not one that satisfied 3211G.
You know,
but that doesn't matter.
Sorry, you're right.
No,
Go ahead, finish. Go ahead, finish, counsel.
Yeah.
What I'm saying is, very simply, the complaint pleads that regardless of whether the statements are true or false, they violated the confidentiality provision of the agreement. In our motion, at the time, until the court said that the only way for the plaintiff to get through the litigation privilege was to prove that the statements were false, there was no occasion to make the SLAPP argument because there was no need there was no need in the complaint to prove falsity. If it was true, they win under their breach of confidentiality clause, according to them. The first time that falsity became an element, a necessary thing for them to prove, was when this court recognized an exception, a new exception, that said you must, to get around the litigation privilege, prove two things. There was extortion and threats of perjurious testimony, false testimony, not true testimony, false testimony, and then you have to go and communicate the allegedly false, not true, testimony to the other side. And why that's critical is that there is a breach of confidentiality clause at play here. If the statements are true and they're confidential, then there is an argument that is to be made that there is still liability. It's only when the court says you only get liability with false statements, that the slap defense becomes available, because at that point, actual malice becomes an issue. Actual malice is essentially an issue of what was the defendant's state of mind at the time he's alleged to make the false statements. It didn't matter under the original formulation whether or not the statements were true or false. If they were true, it breached confidentiality. If it were false, it might breach non-disparagement. But the moment the court said the true statements do not get through, it's only the false statements that get through, that's the moment at which the ability to plead a defense under 3211G for actual malice holds. And the critical thing that Justice Schechter found, which was underlying this entire thing, actually, she found two critical things. One is I can tell you that Justice Schechter does not believe that the privilege will survive the test under Gottwald. And that's one of the motivations that Justice Schechter had. But secondly, while the complaint is long on allegations of extortion, it is beyond light on falsity, to the point where there are two words in the complaint, false, and they don't say why. They don't say that Mr. Yadid allegedly knew that what he was saying, allegedly was saying to the lawyers for Adidas and Reebok were false, under a mountain of evidence from the Reebok complaint that were placed in front of Justice Schechter, showing that there was trademark infringement here. And Your Honors, we're not talking about something that is light here. This is testimony in court. We're not saying that the court should, right now we're not saying that the court should undo the exception that it made, to the litigation privilege. But there have to be some sort of standards. If there's an allegation of perjury that are unsubstantiated by one single fact as to why the testimony was allegedly false and how the plaintiff knew, then what good is the litigation privilege?
Okay, thank you, counsel.
You're welcome. Thank you, Your Honor. I appreciate the time.
Absolutely.
Thank you, Your Honor. A few brief points. Paragraph 10 of the complaint, which hasn't changed since we filed it, in fact, nothing in the complaint has changed since we filed it, alleges, of course, Jack Yadid, the defendant, knew that his threatened testimony for Reebok, although false, would compromise TRB's defenses in the Reebok litigation. Falsity, therefore, has always been an element of what we've alleged, and therefore there's nothing that's changed as a result of this court's decision that somehow set off a light that all of a sudden falsity is at issue.
Sir, vis-a-vis the single motion rule and your friend's argument that going into appeal number one here, you could have prevailed under either truth or falsity. We now know through the lens of this court's first decision that it became a pure falsity case. Does that not change the landscape sufficiently to permit the second 3211 motion?
No, Your Honor, and the reason is this. Let's just step back for a second and think about what the anti-SLAPP argument is here. The argument is, as it must be, that as a result of the allegations concerning Mr. Yadid's proposed testimony, that Mr. Yadid, the defendant, should have been allowed to speak, should have been allowed to talk to Reebok's lawyers or talk to the court in the Reebok litigation about the matters that he wanted to talk about. And the plaintiff, by virtue of bringing this case, has somehow chilled or stifled that ability without any merit. That's what an anti-SLAPP argument is. That argument, that defense, existed regardless of whether or not
Let me
there is
ask you,
truth or
counsel,
falsity.
one real quick question. This court reinstated the entire complaint, right? Didn't say anything. All that this court said was, to the extent that the lower court says that the absolute litigation privilege bars this claim, we disagree. But it didn't say anything about falsity had to be. I didn't see anything in that. I just looked at it again that said the only way this can go forward is if you prove the statements are false. It didn't say that, right?
It did not say that, Your Honor, but in fairness to counsel's argument, the court did say that with respect to at least this aspect of the claim.
Right, this aspect.
Correct, exactly right, Your Honor.
It didn't say that, it didn't say that because the defense was raised. That's what was raised. That was what was in front of it. Didn't say anything about whether or not the non-disclosure agreement would apply regardless of whether the statement was true or false. All it had occasion to look at in that last appeal was whether the whole speech, the speech was barred, claims about the speech were barred by the absolute litigation privilege, right?
Correct.
I thought I was.
Your Honor, if I may?
Last statement.
Last statement. In the event that the court wishes to look at the anti-SLAPP statute and look at whether or not the plaintiffs have satisfied it, I would just point out that 3211G provides that in order to defeat an anti-SLAPP motion, the plaintiff has to show that there's a substantial basis in law for the claim. As Your Honor indicated, this is a breach of contract action. You breach the contract and you're liable for it. That's a substantial basis in law, and it should be denied on that ground as well.
Thank you, counsel. Thank you both. Portfolio Media.
Good afternoon.
proceed, counsel.
May it please the court. Matthew Leash for Appellant Portfolio Media. The trial court here held that where an agency constructively denies a FOIL request, but then proceeds to issue a whole series of substantive decisions, including producing some documents, asserting exemptions as to others, and expressly telling the petitioner it has a right to appeal those decisions, the statute of limitations for all of those subsequent decisions continues to run from the date of the initial construction.
Well, in this case, is it your position that the respondent created an ambiguity as to the constructive denial?
At the very least, it created an ambiguity.
And how so?
It created an ambiguity by when Portfolio appealed the constructive denial, instead of ruling on that appeal, the respondent said, okay, now we're considering your request. They ruled on the request and denied it on substantive grounds. They declared the constructive denial moot. When they issued the denial, they said you have 30 days to appeal that denial, which Portfolio did. They ruled on the appeal and granted it in part. On remand, they produced some documents, and then they issued a final response saying, you're not getting anything else. We have more documents. We're not giving them to you. You have 30 days to appeal this. Then they turned around and argued to the lower court that none of that mattered. The clock was running from the time of the constructive denial that they themselves said was moot. And so at the very least, that creates ambiguity, and under the Court of Appeals Monday line of decisions, any ambiguity has to be resolved in favor of the petitioner here. We submit it even goes beyond that. It wasn't even really ambiguous. It clearly was not a final decision. There were subsequent appeals. The respondent said you have a right to appeal, and it considered one of those appeals. That is a subsequent final decision that gives rise to a separate right to bring an Article 78 proceeding. So the trial court here really disregarded that whole body of law. There are decisions, none from this department, but from the second and third department in very similar circumstances where an agency initially engages in some sort of constructive denial, but then turns around and gives a substantive response, where the courts have said, okay, the clock was not running from the time of the constructive denial. That just doesn't make sense. It can't be the law. If that decision below is correct, this gives rise to the potential for a flood of unnecessary litigation. You're going to have situations where an agency constructively denies a request, then turns around before the 120 days is up and says, okay, here, we'll give you something. We're going to give it to you the day after the 120-day period. The petitioner is going to have to go ahead and sue to preserve their rights, even though, in fact, the agency might plan to give everything that was requested. It just doesn't make sense as a matter of law. The court below also made a couple of secondary rulings that are internally inconsistent and also are wrong as a matter of law that we would request be reversed as well. First of all, it said the 30-day clock for an administrative appeal begins to run from the date of the request. That's clearly not correct. At most, it begins to run from the date of the constructive denial.
Well, sir, among this mosaic of decisions or potential decisions, when do you think was the earliest final determination that you were bound by and required to bring your Article 78 within 4 months of?
Well, we would submit that it really didn't begin to run until the agency refused to consider the final appeal of the final response letter, because the first appeal the agency granted in part and remanded. The agency then produced some documents, issued a final response letter saying you have 30 days to appeal that final response, and that was the first time it raised the privacy exemption. That was the first time it acknowledged possessing complaints and certain other documents that it was not producing.
Counsel, a date would be useful. So would that have been August 5th, September 16th, or September 22nd?
So August 5th was the date of the final response letter. Portfolio then had 30 days to file their appeal from that, which they did, and then the agency refused to consider that, I believe, on September 16th. So we submit that it was the September date that matters, but even if the court considers the August date, the petition here was still timely.
So your date would be September 16th or September 22nd?
Are you timely?
Would they be timely, all of them?
They're all
Within
timely.
4 months, within 4 months of.
They're all within 4 months. Even if the court goes back to the
August 15th.
decision on the substantive appeal, that's within 4 months. The only thing that's not within 4 months is the constructive denial.
Okay.
So I don't think the court needs to get to estoppel unless it concludes that this, the court was correct below, but I would just rely on the papers on the estoppel.
We're good. Thank you, counsel.
Thank you.
Good afternoon, Your Honors. May it please the court, Robin Rothman for the Office of Court Administration. Supreme Court correctly decided that constructive denial of administrative appeal of a previously denied FOIL request.
So my question to your adversary was did OCA create an ambiguity? And the response was yes. But isn't that a correct statement? That just based on the chain of events, there's a constructive denial, records are produced, the records officer said you have 30 days to appeal, and we can go through all the dates. When is the petitioner supposed to appeal? When he's getting records, or it's getting records, and it is being told they have right to appeal. Why shouldn't they take OCA at its word?
Well, Your Honor, I would say that there was really no ambiguity here, because even at the when OCA constructively denied the request, that is essentially sort of a blanket denial, right? There's no response. It's considered denial under the FOIL law. This court has determined that constructive denials are final and binding as to trigger the.
And then what did you do after that?
And although
what did you do after that?
Well, after that, there was an acknowledgement, a belated acknowledgement, which petitioner actually said, oh, no, you're too late. I've already filed my constructive denial appeal, so you're too late on the acknowledgement. And then OCA, yes, we did provide a blanket denial, which did have a substance to it, but it still outright denied the FOIL request.
But you would deny requests and you say you have 30 days to appeal. Why shouldn't the petitioner take you at your word?
Well, here's the thing, Your Honor, is that the FOIL law does not provide that a petitioner gets multiple appeals simply because they don't like a response that they've got.
No. It's not because they don't like the response. It's because you keep moving the target. First you say no, then you say yes, then you produce some documents, then you don't produce documents. That's why they get the extra time, not because they're doing anything, it's because of what you're doing. If your position is you don't get documents, then you don't, a month later, give documents. That creates the ambiguity. That's the problem.
Well, Your Honor, I would posit.
So what you're saying, let me just finish this, is that you have to take an appeal from the first one, and the second one, and the third one. That makes no sense.
Well, Your Honor, I would say to this is that there are most of the case law regarding at least constructive denials.
There's no further, there's nothing going on.
I understand that, Your Honor. And if I just let me make this point, is that most of the case laws regarding this particular issue with constructive denials, it's not an unusual circumstance. Sometimes in Article 78 does wake up an agency and documents are provided.
Counsel, for OCA not to be woke is sad.
Well,
right? For OCA not to know how to do this right is sad.
Well, I will.
You cannot string a party along. This is supposed to be okay. So here you have lawyers, but a lot of times you don't have lawyers. Okay, you have just regular old people, and to say you've got 30 days more to do your administrative appeal. we're remanding this. We're remanding this as to this, but not to that. You've got 30 more days. That's plain language. 30 more days means 30 more days, doesn't it?
Your Honor, I would agree with you, but I think the issue here is that there was first a constructive denial, and then there was a blanket denial of that first appeal. There was essentially two determinations on the first appeal. One would be the constructive denial, and then it would be a blanket denial because the FOIL appeal officer...
So OCA could have said, please take a look at our letter of blah, 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 which was a blanket denial. Don't be sending us anything else. Now you go to the appellate division.
Well, Your Honor, I would just say that this court has determined that one, constructive denials are final and binding, which is to trigger the statute of limitations.
Yes, but can we agree that in those cases there aren't subsequent actions by the agency that create the ambiguity that they have reconsidered, the agency has reconsidered its initial denial and has sort of started the clock running again?
Well, I would actually...
There's nothing that the petitioner did, right?
Well, there are certain things that the petitioner did by continuing to say, are you going to give me more documents? Are you going to give me more documents? I mean, at that point, he knew that there was at least some documents that were not going to be forthcoming. And if I just would make a final point as to what you were saying, that some of the cases, there aren't documents that come, I would say the Lambro case, actually, that case, there was an issue with regards to the agency kept saying, we're coming out with, we need more time, we need more time, we need more time. The petitioner themselves determined, you know what, I've had enough time waiting, you keep stringing me along, saying that records are forthcoming, but you need more time. I'm going to deem it constructively denied, and I'm going to file my Article 78. As soon as the Article 78 was filed in that case, that's when the agency was able to produce the records. But in that case, the petitioner was aware that records were forthcoming. It just was at a too slow a pace for the petitioner. So these types of circumstances are not necessarily unusual in FOIL cases, right? Sometimes it happens. And in that Lambert case, this court said, okay, you file your Article 78 deeming constructively denied, you've since now gotten records, but because these substantive denials are not before this court, we can't determine it, and you never moved to amend your pleadings. And that would be the saving grace here, right? So if the petitioner was able to file their Article 78 and then receive documents or receive a substantive denial that still aggrieves him, there is an ability under the CPLR 3025 to amend the pleadings to include that. And I think that that's what should have been done here. And
Thank you, counsel. That's more than one point.
Very briefly, Your Honors, on the Lambro line of cases. Those were cases where the production was made after the Article 78 was filed. Here, the respondent is essentially arguing that Portfolio had to sue for the constructive denial when it had already received documents and was told there might be more coming. It's not a parallel situation. And the last point I'd like to make is just on the blanket denial appeal. I want to just correct a misstatement. The blanket denial appeal was not a blanket denial. The appeal was granted in part. There was a blanket denial. On appeal, the agency upheld the narrow substantive point that was made by the agency below, but then said, we think there's more responsive documents, we're remanding for further review. And on review, the agency produced some documents and raised new exemptions. So we think this is a clear-cut case of error on the part of the trial court.
Thank you, counsel. Thank you both. Tribeca Prep.
Good afternoon, Your Honors. I'll begin. Good afternoon, Your Honors. Dan Goldstein of Smith, Gambrell, and Russell, LLP, for the plaintiff appellant Tribeca Preparatory, LLC. May it please the court. This is an appeal of the lower court's decision granting in part the defendant's motion to dismiss pursuant to CPLR 3211A7 based on the pleadings, the decision with respect to the breach of fiduciary duty claim was erroneous for at least 3 reasons, which I would summarize. First, the decision erroneously held that the allegations in the complaint failed to state a claim. Second, the lower court improperly relied upon evidence outside of the 4 corners of the complaint in reaching its decision. And third, in relying upon evidence outside of the complaint, which it should not have done, the lower court reached the wrong conclusion. Just as some preliminary background, Plaintiff Tribeca Preparatory LLC is a school for special needs students. The defendants held various positions in the LLC. Defendant Aninias, at all relevant times, was a manager on the board of managers of the LLC. She was also the school's administrator and head of school. Defendant Sparber is a member of the LLC. The complaint in this case, it's on page 20 of the record on appeal. I'll be referring to it. On pages 27 to 30 of the record, the complaint pleads in detail the defendant's misconduct and actions forming the basis of plaintiff's.
So let me ask you about the provision of the operating agreement that is entitled Other Ventures, because you know that's the crux of the case.
I'm sorry, Your Honor, I didn't hear it.
You can't hear me? Sorry. Let me ask you about the provision entitled Other Ventures that's found in the operating agreement. So in the very first line, it says, and this is at Record 53, the members and members of the Board of Managers may independently or with others invest or engage in other businesses or ventures, including activities similar to that of the school. So here your adversary argues, that's it. We did engage in another venture, and it was similar to the school, and this operating agreement allowed us to do it. And forget about a fiduciary duty. We didn't have a fiduciary duty. We were exempted from that because of this. So what do you say?
Well, that's what the lower court did, relying upon the operating agreement, and that was one of several errors that the lower court made. First of all, it should not have been relying at all upon the operating agreement. This was a motion to dismiss based on the pleadings under 3211A7, so the court should have determined whether or not the allegations in the complaint stated a cause of action for breach of fiduciary duty without relying upon any outside evidence.
Did you plead the operating agreement in your complaint?
The operating agreement was addressed in the complaint.
So then that is, if you plead it in the complaint, then the court can look at it on a motion to dismiss.
Well,
all right, so let's keep going.
even if the court were to look at the complaint, it is not a complete defense.
Well, so let me ask you this. Does the joint venture, the other ventures provision, does it permit the defendant to allegedly use, for example, confidential proprietary information to promote the competing school?
Exactly, Your Honor. While the operating agreement allows the defendants to compete, what it does not allow the defendant to do is, in their fiduciary capacities, to misappropriate information, contact information, names, numbers of the schools.
And what confidential information are you alleging that the defendants used, which would be allegedly a breach of fiduciary duty?
When they were still in their fiduciary capacities, they were contacting the students, parents of the school, soliciting them to leave the school and to instead follow them to their new school. They were they were soliciting the faculty of the school and soliciting them to go with them to their new school.
And here the new school was coexisting on the same floor?
Exactly.
As
So
the
that's
plaintiff's
another.
school?
Exactly. So using the plans of my client's school, the plan was to expand into the floor above within the same building. The defendants instead did that same exact thing using the same plans, opened up a new school in that very same space in the same
So
building.
you're saying that's the confidential information used to open the new school?
It's one of several pieces of confidential information that was used. Using the plans, contacting the parents, contacting the staff. It was steering everything away from the school, gutting this school in breach of their fiduciary obligations. They were still.
When you're talking about gutting the school, did you just say that?
Yes, Your Honor.
So normally when I think of a school, I think of something big, right? But here there were 15 students in the school.
Correct.
And they're special needs students, and if I may be so bold, the big tuition, a very high tuition. So how does that play into your allegation that they were, or statement just now that they were gutting the school?
The operating agreement allows them to compete. So the plaintiffs could have, defendants could have formed another school and tried to get other clients, other students, tried to get their own staff, and competed.
But if they can compete, the agreement clearly provides it, why shouldn't they be able to solicit teachers and students without using confidential information?
Because at the time they were doing this, they were still fiduciaries of the school. She was, the defendant Ananias was still a member of the board of managers. So what she was doing by contacting the school students and the school staff and soliciting them away from the school, she was breaching her duty to the school.
Thank you, counsel.
Good afternoon, Your Honors. You were right, it's a hot bench. It's been an interesting afternoon listening. Your Honor, I represent the defendants in this case, and it's very clear that my client, the defendants, didn't do anything wrong. The operating agreement was an arm's length transaction, negotiated, both sides had counsel, and they both had the opportunity to negotiate that clause. It was
The allegation, and I understand the argument, but the allegation is that you allegedly used confidential proprietary information to promote your school during a time when you were when your client was still a member of the LLC.
And Your Honor, that is contested, and it's not disputed by the
Yeah,
defendant.
but that's not a pre-answer motion to dismiss,
It
right?
isn't, Your Honor. However, there's I wouldn't say an exception. There's a circumstance that needs to be taken into account. This action was commenced by the filing of a summons and complaint, and contemporaneously, in order to show cause, seeking a temporary restraining order and a preliminary injunction. We went in and argued and submitted papers on that temporary restraining order and injunction, and the Judge Frank, denied the substance of the temporary restraining order and said, you can go open the school. You can go open the school. Part of the papers that were submitted, which I submit to the court, may be considered as, they're part of the record here, and they can be considered on the motion to dismiss. There is a timeline that was in the affidavit.
It's an A7 motion.
It is, but
so just what you're asking us to do essentially is to weigh facts on an A7 motion, aren't you?
Well, they're facts that were in the record before.
No, I'm not disputing anything you're saying.
Even assuming that's...
We have, I mean, I can...
Taking the four corners of the complaint, looking at the complaint, she did not announce that she was opening a new school until after she resigned.
But the claim is not that. The claim is that you used their confidential information while she was a member of the LLC. I don't know the truth of that, but that's the claim.
So, Your Honor, and that only relates to the one cause of action that was actually sustained.
But that's
No, it's breach of fiduciary duty.
No,
You are fiduciary.
the cause of action that was sustained was the misappropriation of confidential information or trade secrets. All the other claims were dismissed, and that's what they're appealing.
But what I guess, no, they're appealing the fiduciary duty claim, right?
Correct,
And the allegation is you are a fiduciary because you're working at the school, and as a fiduciary, you may not use confidential and proprietary information.
So
that's not controversial.
I can respond to that, Your Honor, very simply. In 2007, my client established Ready, Set, Play. They're a named defendant here. Ready, Set, Play was in existence long before the plaintiff became into existence. In fact, Tribeca Preparatory School rode the coattails of Ready, Set,
There's no question. There is
so she already had this information.
But there's no what? She knew the names of teachers, students, parents.
Yes, because many of the teachers and the students.
Okay, but that's
for summary judgment.
But what I'm saying, I understand that, but there are allegations on their face. Many of the teachers and the students that were already, to her knowledge, because they were clients of Ready, Set, Play. So in essence,
but you can understand how we are saying to you, that's her view and that's her testimony, but it's not conceded and it's not enough on a pre-answer motion to dismiss.
But I understand that, Your Honor, but I think there is no dispute, and I think it's in the complaint as well, that Ready, Set, Play was in existence prior to the school.
Okay, is there an allegation in the complaint that she took proprietary names of individuals who were at the school and solicited them at a time when she was still working at the school?
The allegations in the complaint on the record, R28, are, for example, and they cite certain bullet points within there, and those bullet points relate to conduct that she did after she had already resigned.
But that's not what they say
But
in the
that's what's in their
complaint.
complaint. That's what they
Oh,
pled.
they're saying that after she resigned.
Yes, she
did those
resigned on April 30th.
Right.
Okay, and they write in paragraph 53 of the complaint, on May 4th, Ananias announced to the school staff and families that she was launching the Shirley and Aeneas School. On and
Counsel,
following May 1st.
there's statements that relate to events and acts before the point in time where she resigns, yes?
The statements that I'm referring to.
Not what you're referring to.
Well, no, these are what they alleged in their complaint.
Besides the ones that you're reading to us, aren't there a lot of allegations of events that took place before the actual resignation?
The allegations in their complaint, very interesting that you bring that up, Your Honor. In paragraph 53 of the complaint, those allegations don't have any dates next to them. And there's a very good reason for that, because it didn't occur. My client was very careful to make sure that she honored her obligation.
So your arguments are properly made on summary judgment, right?
No, I think that the plaintiffs are cherry picking in terms of what they put dates on and what they don't. And I think that not only did they cherry pick with those allegations, but I think it's pretty telling that they refer to the operating agreement in the complaint, but they fail to make note that the operating agreement specifically allows her to open a school. You have to be forthright.
Again, that's not the basis of the claim.
Yeah.
The basis of the claim is and for the purposes of what we're dealing with, got to assume the truth of the allegations, giving the plaintiff every favorable inference, et cetera, is that you use confidential and proprietary information informing your school, including taking plans that allegedly the plaintiff had to expand and taking that for yourself.
But
those are the claims.
The only way that she could have potentially breached her fiduciary obligation in that sense is if she had done it while she was still employed
That's for
there.
summary judgment.
But Your Honor, they don't plead that in their...
But we're telling you the same thing.
Your Honor, they're not pleading with the specificity required by 3016B, and that would require that they put in dates of what the alleged conduct occurred, and Judge Frank very keenly picked up on that in writing his decision, that it doesn't meet the level of particularity required by 3016. They didn't put those dates in the complaint in paragraph 53 because they can't, because it didn't occur, and that's not a summary judgment motion. That's cherry picking on their part.
Okay, thank you, counsel.
Thank you, Your Honors.
Okay, counsel.
Yeah, I've got to ask you.
Go ahead, ask.
Just very succinctly, Your Honor.
I mean, right. If all you are alleging that after she left, she opened up a competing school, is that what you're alleging?
That is not what is alleged.
Are you alleging that while she was at Tribeca, she was taking information?
Yes, Your Honor, as
correct?
pleaded in the complaint.
Where do you, for example, allege that, sir?
Well, as the date the complaint was filed, she was still a member of the Board of Managers of the LLC. She was terminated as the administrator from the LLC on May 17th.
I'm just asking, does the complaint allege that she took information while she had a fiduciary duty not to?
Yes, that is pleaded in the complaint.
And when do you think her fiduciary duty not to ended?
Her fiduciary duty ended when she was no longer affiliated with the LLC, which she was at all relevant times in the complaint.
Okay.
And are the pleadings in that regard with respect to breach of fiduciary duty, do they satisfy the more demanding standard of 3016B? Because clearly you have areas in your complaint where you have plainly labeled a cause of action as breach of fiduciary duty, but we know more is required of the pleading in this regard.
Yes, absolutely, Your Honor. I would submit that between pages 27 and 30 of the record, The complaint is alleging in specific detail the actions that were taken by the defendant.
Prior to, while she was still in a fiduciary.
While she was still in a fiduciary, and to the extent that there are factual disputes about that, it's not appropriate on a 3211A7 motion.
Thank you, counsel. Thank you both. Okay, folks, Burr versus Crary. Hope you had an interesting afternoon.
Last, hopefully not least.
Never.
Good afternoon, may it please the court. My name is Robert G. Smith, and I represent the appellant. Defaults have consequences. The motion was made for a default judgment. And the fact of the default is not contested. It's admitted by the respondent's counsel and by the respondent. The judge in the court below did not address the motion that was filed. The judge in the court below decided to say, well, I'm going to cherry pick a venue issue and address venue.
Why is that a cherry picking? There's an agreement about where venue can lie. There were discussions between the parties about that. Why shouldn't your adversary be able to enforce what the agreement was with respect to venue?
Because my adversary was in default, and under Section 3012D of the CPLR, the only rights of a litigant in default, a defendant, is to make a motion to vacate the default, and then to litigate if the motion is granted. And there are no grounds in this record to grant that motion anyway.
But the court below didn't decide those issues, right? It looked at venue and said venue shouldn't be placed in New York County.
And proceeding, I'm sorry, I interrupted.
And made that decision.
And proceeding in that fashion constituted a gross abuse of discretion.
So, counsel, what about, I'm trying to figure out how to reference it right. Section 202.50 of the court rules. I'm not saying the citation correctly. 22 NYAC Section 202.50. It requires enforcement of a settlement agreement to be brought in a county where one of the parties reside, provided that if there are minor children of the marriage, the application shall be brought in the county where one of the parties or the children reside. So isn't the agreement between the parties a mere mirror of what the rules require?
No, it is not. And this raises the question of incorporation and survival of a contract provision versus merger in the subsequent judgment.
So you're saying that the judge could just ignore that?
The judge could ignore, I'm sorry?
The judge could just ignore the rules?
It's not required by their agreement. They have a contract. This is a breach of contract action. It's not a matrimonial action. It's not a custody action. The Section 320A, the CPLR, has the word shall, that a defendant shall file a notice of appearance within 20 days. That was not done. It's agreed that it's not done. It's conceded that they were in default. And the only defense...
I know that you're spending a lot of time on that issue. Were there discussions between counsel with respect to the alleged frivolous nature of the action? And is it true that your adversaries and maybe the defendant as well believed that the action was going to be discontinued and instead there was a motion for a default judgment?
It is not true. There were no such discussions. I am the person who is alleged to have said that we're going to withdraw the action. That never happened. If you look in the record, I'm sure you've looked in the record. This is a very hot bench. But there was, the respondent stated as soon as we sent the notice of default and the summons of complaint, is this a joke? Are you like Putin? Have you been isolating for too long. This is meritless. I'm going to counterclaim. We're going to get every dime of our counsel fees from you. And then counsel takes the position later, after the default, after the conceded default, counsel takes the position that, well, there was a verbal understanding that that this case would not proceed. Never happened. And if it had, it's reasonable to assume that something would have been confirmed in writing. Counsel threatened me in writing. Counsel stated to me in writing that this was a frivolous proceeding to start with. And then counsel said, after the default, well, you know, I was of a state of mind. All the cases under 3012D refer to the requirement of detail. Mere conclusory allegations are not sufficient to state that there was a reasonable excuse for the default, which is conceded, and there are two requirements: a reasonable excuse and a meritorious defense.
Okay, so well, let me stop you there. The hour is late. And let's hear from your adversary what he has to say about that, and of course, I'll give you the final word, okay? Thank you.
Good evening, may it please the court. So the only issue really before the court is whether or not venue was transferred properly.
Well, that's one issue, but your adversary says the default judgment should be granted. Why don't you address that issue, and then and address the question about whether or not the default under the circumstances was excusable or not?
Yes, well, that goes to meritorious defense, which goes to how preposterous the underlying claim is. The underlying claim is, although the appellant got remarried and maintenance terminates pursuant to the statute, that only counts under the judgment of divorce because it was in family court. There had to be a plenary action in the Supreme Court.
Did she appeal the family court decision?
I'm sorry?
Did she appeal the family court decision?
She did not, and waited 3 years to file this claim. And the only problem is, even if you entertain this contract action, the contract itself says that any modification or change to the judgment of divorce also changes the contract.
And how long has litigation been in Kings County with these parties?
Since the inception, and the parties were in litigation in Kings County when she brought this action. In fact, that case just ended.
And they both live in Kings County?
I've always lived in Kings County since the date of marriage. There is nothing, there is no, the appellant was tried to be clever and say the basis for venue in New York County was that the defendant lived, the respondent lived in New York City.
So, counsel, let me ask you, was it your understanding, you put in an affidavit that said that it was my understanding that counsel was going to withdraw the action. Was that your understanding?
Absolutely. We had a conference with the court, and this issue came up, and how absolutely preposterous these claims are.
Okay, but I'm just trying to figure out, that was your understanding,
yes,
and then you responded when the motion for the default came.
Yes, and again, I did put clearly in writing that we would be seeking sanctions and attorney's fees because this is clearly a just completely frivolous action.
And was there an order in Brooklyn? There was an order in Brooklyn, a consent order terminating the spousal support, correct?
Yes, Your Honor.
And that's, I think, what my colleague was just saying was never appealed.
It was not.
Right.
It was done on consent.
So regardless of what the contract says, there's a court order that terminates the spousal support, which was never appealed.
It was never appealed, and the contract also says that.
Yes.
Okay. So there was, and it is axiomatic that the best place for parties to have their disputes regarding their divorce and marriage litigated is the county in which they reside. The county in which the action was brought was the judgment of divorce was signed, and there was current litigation in Kings County at that same time.
So, counsel, fortunately for all of us, well, we have books on our bench, and I found the right section, and it's the court rules pertaining to the Supreme Court and County Court, and Section 202.50 concerns proposed judgments in matrimonial actions and the forms that have to be used. That language about holding the enforcement of a settlement agreement in the county where one of the parties or the children reside is actually part of the court rules. It also says at 202.1 waiver for good cause shown in the interest of justice, the court in an action or proceeding may waive compliance with any of the rules of this part. So my question here is, with respect to the default, did you ever try to cure the default? Did you ever ask for a waiver of the rules so that your application for a default could be heard?
We did make an application to the...
In Kings County?
There's been no applications made in Kings County on this particular matter. It's only been in New York County. Judge Knott issued his decision. Interestingly enough, there's never been an RJI filed by the...
Thank you, counsel.
Thank you.
We understand. 1 minute, counsel.
And the question for you is
very fast, then.
Let him get there.
The question for you is the opposite. The question for you is similar, but it's the opposite, which is, did you seek leave to waive these rules? These are court rules, on top of the agreement that the parties had between them.
That court rule was never raised before just now, Judge Gonzalez, and this is post-judgment. The question here is there a survival of the obligation? And the answer is in page 51 of the record.
So your answer is that you never sought leave to continue.
And was not required to. Section 248 of the DRL only applies to the judgment, not the contract.
Counsel, I have a question. You wrote in your brief, it appears that the assigned justice, I assume that means Justice Knock, has engaged in deception and misdirection.
Yep.
That's a pretty strong thing. What in the world are you talking about?
Well, the judge...
What deception?
The court below quoted only the first part of CPLR 503A, which is the venue statute, and that does refer to residents. However, that statute was amended in 2017 to include also a place where substantial activities occurred or omissions.
But in this instance, wasn't the court simply applying the agreement, saying the agreement, in effect, overrides whatever venue provision you're citing?
The parties did not sign the agreement. I'm sorry, that section is not part of the agreement that the parties signed.
Okay.
There's a boilerplate provision that involves custody and says it should take place, modifications should take place in the county where the children reside. However, that's not what the parties signed. This is only a breach of contract action, and it only affects the durational spousal maintenance provision in the contract, which survived. And the defendant's entire position here is that the family court order under Section 248 of the DRL, which was on consent, also eradicated the surviving provisions of the Article 3 of the settlement agreement. Their position is that that automatically resulted in an eradication. Well, I'm sorry.
Thank you.
It's late. I'm
Finish
sorry.
your thought. Finish your thought.
Thank you. Thank you. The question is whether the obligation to pay spousal maintenance, which is contained in the contract, which is on the first 10 lines of page 51 of the record, survives the remarriage of my client. And I've given the court all of the cases which show that it does. The public policy of New York permits spousal maintenance to be paid or obligated to be paid in a contract after remarriage. Their position is that
Thank you, counsel. I think we get your position. Thank you.